Morning, members. To the delegation from the NPA. Can we get an indication who's going to be sharing from the NPA and possibly two people, so that if the other person has a problem, the other one can assist?
Yanis he's connected.
Oh yeah, I'll make you back up, because if he then has any other problems as you've indicated, we'll then have to assist. Can you test the system? Can you hear me?
Yes, we can.
I'm asking.
Yes, we can hear you.
Can you
Yani?
test?
I'm going to test now. I'm just going to put off my camera.
Please put off your camera, Yani.
Yeah, it seems to be working. It's fine for now. So both presentations will be shared by yourself?
That's correct, yes.
Oh, okay. Just to test the audio on who's going to be leading the delegation. Is Advocate Cox audio correct? You can remove the presentation for now, sir.
Good morning. Good morning, everybody. I am in Cape Town. There is going to be load shedding apparently at 10. I'm in Cape Town CBD. So I am on my cell phone Wi-Fi. So I hope this will hold chairperson. Because I've decided to just connect on the cell phone Wi-Fi as
Recording in progress.
As opposed to the office Wi-Fi, because it's going to be cut out at 10 because of load shedding. So I hope that everyone can hear me clearly.
I know your audio is correct, Advocate Cox. Yes, until the chair calls upon you. Thank you.
Thank you.
Good morning to everybody. Can we start? Let's start by welcoming the delegation from the NPA, led by Advocate Rodney de Kock. We received an apology from the National Director of Public Prosecution. She is out of the country. So the delegation will be led by Advocate de Kock. Are there any other apologies?
There's also an apology, Chair, from Advocate Omar Rabaji, the Acting Special Director of the Asset Forfeiture Unit, Ms. Lulaman Ngoko, will be doing the presentation. in relation to the aspects relating to the asset forfeiture unit. Thank you, Chair.
Okay. Let me first get a sense as to the apologies from members. Are there any apologies? No apologies. But we will note the apology of Honorable Janji, who is attending the Magistrates Commission. Advocate de Kock.
I'm lucky to join today. Thank you, Chair.
Oh, no, good. Thank you. Thank you very much. Advocate de Kock, which one are you going to start with?
We'll start with the presentation that was postponed on the last occasion, Chair, because of time constraints. So the one dealing then with the state capture corruption, the Zondo Commission report, that is the one that we start with.
Okay. Members, please note we will be proceeding at 2 to deal with the NPA amendment bill. So today we'll have a long day. After meeting with the NPA, we will proceed at 2 to finalize the NPA bill. Honorable Breitenberg, followed by Honorable Janji.
Thanks, Chair, and good morning to everybody. I have declarations in the House, so I'll join as soon as I can.
Oh, okay. I guess Honorable Horn will be here with us, or Honorable Engelbrecht.
Yes, they will both be here, but I would also prefer to be here for that particular piece of legislation. As you know, it's not my fondest thing to do.
Okay. Honorable Janji.
Yes, Chair. Same. I was going to say I'm going to start in the House with a ministerial statement on the planning, monitoring, and evaluation. I hope to join up immediately after that. Thank you, Chair.
Thank you very much. Thank you, members. Can we hand over to Advocate de Kock?
Thank you very much, Honourable Chairperson and honourable members of the committee. We really welcome the opportunity to engage with the committee in relation to the work of the NPA as far as the State Capture Commission report recommendations are concerned, and the progress thus made. We note that this is a meeting that was adjourned from a meeting some time ago when the SIU and the DPCI had already presented to the committee, and the NPA was requested to present at the end of those two presentations. So this is then the presentation of the NPA. The presentation itself was submitted to the committee members some time ago.
Sorry, Advocate de Kock. Honorable Breitenberg, is that a new hand or an old hand?
Sorry, it's a very old hand. Thanks.
Thank you very much. Sorry for that. Advocate de Kock, you can proceed.
Thank you. So the presentation was submitted to the members of the committee at the time when we were last in Parliament. Just in terms of, if we can move to page 2, just in terms of the scope of the presentation, we will deal with an introduction. We'll talk briefly about the integrated task force. I'm not sure if this is the correct page that we're on. Advocate Schutte, is this the correct presentation that you have on? Because mine is slightly different to yours. Just be sure that we have the correct presentation that's reflecting.
Yes, Yanni, you're flighting the annex chart, not the main presentation. Please change.
Chair, if you can just bear with us for a minute. There's an annexure to the presentation that sets out in some measure of detail some of the statistics. The idea is that we, unless the chairperson requests us to go through that in detail, we have submitted that to Parliament. The first part of the presentation is an overview and highlights of our progress. So if I can just get the colleagues to take down this presentation on the screen at the moment. This relates to the annexure, and we're looking for the first part of the presentation. But Chair, while they are busy with that, I will proceed. The presentation takes the form of an introduction. We briefly talk about the integrated task force. Then the investigating directorate will be presented, the work of the specialized commercial crimes unit, and then the asset forfeiture unit, and then we'll make some concluding remarks. By way of introduction, we do have Advocate Andrea Johnson, the investigating director. She, as the head of the ID, she is present to do her part of the presentation. We also have Ms. Lulama Ngoko, who is the acting special director in the asset forfeiture unit. I also have present in the meeting Advocate Lebo Boloy, who is the special director for the SCCU. And so these colleagues will assist with parts of the presentation where required, and also with the questions that Parliament may wish to pose to us. If we can move to the next slide. Slide 3. Looks like we're having challenges with the slides. I will proceed. Responding to serious corruption is a priority for the NPA. And in our many visits to Parliament, we have emphasized the importance of this work. Internal initiatives and external engagements with partners have been introduced to ensure that there's a systematic and strategic response to the recommendations of the Zondo Commission. At an external level, we have established an integrated task force. This consists of the NPA, the DPCI, the FIC, and the SIU, and of course all internal units of the NPA, the ID, the asset forfeiture unit, the serious commercial crimes unit, the tax unit of the NPA are also part of the integrated task force. And we have also coordinated the work in terms of the FATF report and the FATF grey listing of the country through the establishment of a law enforcement work stream. And the NPA also coordinates the work of the work stream. This is, of course, interconnected with the Zondo Commission report, because some of the action items relating to the FATF speak to our response to deal with the Zondo corruption arising from the Zondo report, as well as asset recovery. Internally, the rebuilding of the NPA to deal with state capture, the effects of state capture has been an ongoing process. We have done much to reinforce and to capacitate the investigating directorate to do its work. We also have done a significant resourcing in our specialized commercial crimes unit, where the work with the DPCI is prioritized. The committee will recall that in terms of the DPCI legislation, the national director is to have a dedicated team of prosecutors available to do the work of the DPCI directorate. And that is what we have put in place. Through the various structures we've set up, we are prioritizing the Zondo Commission work. And we are also in the process of revitalizing the asset forfeiture unit for proactive and enhanced impact. Significant progress in dealing with the state capture corruption matters have been made. And just to reflect on some of these, can I just ask, are we having challenges with the, because the presentation is not moving at all, colleagues. It's still stuck on page 2. Perhaps it should be taken down and then put up again if we're having challenges with the presentation. Significant progress in dealing with the state capture and corruption matters have been made. The ID has declared 99 investigations and enrolled 34 cases involving 205 accused persons. The SCCU and our directors of public prosecutions in the regions have enrolled 78 cases involving 363 accused. These are matters in relation to serious corruption. They are matters that are more than just dealing with the recommendations of the Zondo Commission, but they also speak to state capture. And so these cases are from the Anti-Corruption Task Team, as well as the National Priority Operational Committee from the priority list that we work through those structures, external structures to the MPA. I think the DPCI would have spoken about the National Priority Operational Coordinating Committee. The AFU and partners have secured freezing and preservation orders to the value of 14 billion and recoveries to the value of 5.4 billion, inclusive of the landmark case in relation to the recoveries made in the ABB case. So we submit as the MPA, as the prosecution authority and the prosecutors working on these matters, that the narrative that the MPA is doing nothing is both wrong and dangerous. The prosecution of high-profile government and private sector actors is taking place. A lot of work is being done through our various investigating agencies, and we submit that impunity no longer prevails. And this is the message that prosecution sends out to society and to other actors, that impunity for corruption no longer prevails in South Africa, and the prosecuting authority with its partners are hard at work to address this. The Zondo Commission findings do not provide a blueprint for successful prosecution of cases. Successful prosecution is far more complex, and the test in a criminal court is of a far more onerous nature. But the work of the Commission is valued in that the Commission has opened the gateway, and through its recommendations has pointed the way in terms of areas that law enforcement need to focus on. And that is what we have been doing since the release of the final report in June of last year. So our approach has been one of case prioritization, prosecuting cases that will deliver the most impact. So evaluations are made by our prosecutors and investigators. The question of impact and the question of prioritization is always something that we can debate. But from our point of view, the message that we want to send is to instill confidence within the public sphere, and so that South Africans know that work is happening. And so through that, we have to look at the volumes of cases that we have, the volumes of investigations that we have to do, and look at that work and see how best we can manage that work in order for our cases to be enrolled as speedily as possible and for investigations to be finalized. We also focus on cases that have been the most damaging potentially to our constitutional democracy. And so we take those factors into account in terms of how we prioritize these matters. So there were three key requirements that we had initiated in terms of this approach. We have established the investigating directorate to deal with the question of the Zondo reports. You will recall that our approach in this regard is that the investigating directorate is the lead agency as far as the recommendations of the Zondo report are concerned, but we work in close partnership with our other law enforcement agencies. The current position in terms of the establishment of the agency, we need to reinforce that. So we want to ensure that there's permanence in terms of the structures and the personnel of the investigating directorate. We want to ensure permanence through the process that we currently have in Parliament on the legislative reform and the amendments to the MPA Act. We want to ensure that our partnerships, both with the private sector and with the public sector, are in place, and with other law enforcement agencies. So there's a lot of work that is being done also to ensure that there's private sector support, and we want to ensure that the powers of the ID to fulfill its work and to do its work with all the necessary powers are established. So those are the 3 Ps that are referred to. My colleague, Advocate Anton du Plessis, will also join us in this presentation, and hopefully to the extent that there may be some questions regarding the resourcing model of the ID, he will be able to expand on that. As far as the ID is concerned, we also talk about the prosecution-led investigation model. And we feel, and we've motivated to Parliament as well, that when you put the prosecutors and investigators into teams led by prosecutors, our history has taught us that that is the correct model to use in serious, complex, commercial, and corruption work. So that is the model that we wish to fully engage with in the investigating directorate, and we're confident that when that model is fully functional and we have the dedicated permanent resources, that the work that we are busy with will receive faster attraction. We want to ensure increased engagements and innovative practices to recover assets. Accountability involves not only prosecuting those implicated in corruption, but also seizing ill-gotten gains. The use of non-conviction-based forfeiture, international asset recovery, and corporate alternative dispute resolution is an approach that the MPA is engaging with in an innovative way to ensure that we are able to recover as much money that's been stolen from our country for the fiscus. And so the partnership between prosecutors, investigators, and our asset forfeiture colleagues is a critical aspect of the work that we do. We also put asset forfeiture and recovery at the forefront of what we do. And as I've said earlier, in relation to the Financial Action Task Force action plan, the asset forfeiture is also a critical part of the work that we report on in terms of the recommendations that's been given to us. I speak briefly about the integrated task force before I then hand over to my colleague, Advocate Andrea Johnson, to speak a bit more about the work of the investigating directorate. The integrated task force is chaired by the MPA. In fact, I personally take responsibility to chair that. The importance of a national coordination is that we are able then to coordinate the work that happens within the various offices of the directors of public prosecution. So to the extent that our directors have to prosecute these matters in their individual jurisdiction, the coordination at a national level is critical. And so that is why we established the task force to coordinate the work, and then also to ensure that the work gets the necessary attention from the prosecutors, and that to the extent that there may be challenges in particular matters, we ask questions about what we can do to support that work and how we can ensure that resources are available for us to do this very, very complex and time-consuming work. So that is the task force, and as I've indicated, the investigating directorate is critical to the work of the task force with the DPCI and the SIU. We emphasize that the task force now includes a special investigating unit and the Financial Intelligence Center, and this will ensure broader coordination of investigation and recovery-related work. Again, the focus is on intelligence gathering through the legitimate intelligence agencies, and the FIC is one such key agency when you want to follow money. And so that is why they are critically linked in terms of the work that we're doing. The task force coordinates its work on a quarterly basis. We meet on a bi-weekly basis, and reporting on the progress is submitted to the Office of the President, where the work is then coordinated, and the reports will be finalized through all departments relevant to the Zondo Commission work, through the Office of the President, so that the President is able to report to Parliament as required. All recommendations are addressed. Currently, we finalized 2 recommendations with the conviction. There was one matter in which insufficient evidence was found. Some of the challenges we have mentioned before relates to limited capacity. Our capacity within the investigating directorate particularly needs to be enhanced, and we hope that with the creation of a permanent ID, we'll quickly be able to move to create that permanent capacity within the investigating directorate. The other challenge that the committee is well aware of relates to the congestion on our court rolls, and the fact that when we bring any complex case to our courts, we have to compete with the existing court rolls and the existing cases. And we know that every case in our country, every case on a court roll is an important case. And so it is always a challenge for us to get sufficient time to do these trials. We are concerned that some of these trials are being allocated late into 2024, and we think that there is some engagement that we need to do on this question through the committee, through the Office of the Minister, and through the Office of the Chief Justice. So on the question of trial dates and the time that is made available by the judiciary for us to do this work, it is something going forward in the new year that we'll have to think about very carefully to ensure that when we enroll cases, that we are able to get these cases finalized speedily. So we'll have to do some more work in that regard. But Chairperson, Honourable Chairperson and Honourable Members, I will now hand over to Advocate Andrea Johnson to take the committee through the work of the Investigating Directorate. Advocate Johnson, can I hand over to you, please?
Thank you, Advocate de Kock. Honourable Chair, Honourable Members, as well as colleagues from the NPA, thank you for the opportunity. If we can move to the next slide, colleagues. I'm not going to go into much detail, Chair, on the next slide. It in the main deals with what I'm sure the committee is already aware of, the powers and functions of the ID, how matters are referred to the ID in terms of Section 27, and where the NDPP may also refer matters to the ID. So if it is fine, Chair, may I rather then move on to the next slide. Thank you. Chair, we have found that in the state capture matters, we do require a multifaceted approach. I think we're all keenly aware that in most matters, one had a traditional approach on how to deal with matters. The law enforcement agencies, that would be the ID, the DPCI, as well as members of SARS. And if we talk about the DPCI, the state capture matters are dealt with by the ID in the main, but they're also dealt with by the DPCI, and those prosecutions are conducted by the Specialized Commercial Crime Unit of the NPA, and they will, in this presentation, also deal with the aspects they deal with. But that has led, Chair, to, and honorable members, to us having to consider more innovation. One cannot, in the state capture matters, just deal with prosecutions as one ordinarily did. This was also identified when South Africa went to Morocco in January 2023, that there has to be more innovation. Part of the innovation, honorable members, was looking at what one considers corporate ADRM. ADRM is an alternate dispute resolution mechanism. It is actually a tool that had always been available within the prosecution policy, but had not been used in terms of an alternate dispute resolution mechanism when it came to entities, especially those entities implicated in corruption and state capture. This enables the state not just to have a different resolution, but in achieving that resolution, honorable members, what we sought to do is first and foremost consider whether we would be able to get not just recouping of monies, but whether we would be able to get evidence we could not get anywhere else. That is exactly what happened in the ADRM conducted between the state and the matter of ABB, and where the state was provided with evidence that we were not able to get from other witnesses and or other entities, but we could only get it from ABB. Hence, it resulted then, honorable members, in a payback by ABB to South Africa of 2.553 billion in December of 2022. Another critical aspect on how we consider the state capture matters is looking at the enablers of state capture. I think in the main, ordinarily, when one looked at state capture and corruption, one looked at the principal offenses, looked at principal individuals and entities. But we cannot forget that in the background, we had the enablers of state capture, and the enablers of state capture could have been estate agents, consultants, attorneys, as well as entities. And so in the State Capture Commission, much attention was given to this aspect through the reporting of Paul Holden and Shadow World Investigations. These matters and the various findings of the State Capture Commission were considered by the ID. The ID leads a multi-sectoral engagement with various law enforcement agencies. We have compiled a project plan to deal with the enablers of state capture. This is also critical in the FATF grey listing and one of the measures to enhance the country's fight against money laundering. And to that end, honorable members, the ID has authorized 2 matters with approximately 60 enablers, and the enablers are both individuals and entities. And there are also matters where the DPCI are considering enablers for incorporation into this project. So just to indicate, honorable members, it is not just an ID, it is a multi-sectoral approach, and all of the agencies, including SARS, do bring their matters to a steering committee for consideration for us to deal with the enablers. Thank you. The next slide. The next slide, Chair, merely just sets out an infographic that out of the 202 recommendations made by the Honorable Justice Zondo in the state capture, 122 of those are being dealt with by the investigating directorate. At the moment, we deal with 32 cases. There are 12 matters where there were no specific recommendations. And if I may, honorable members, just pause to add. There are various aspects that have been canvassed on state capture where the commission did not make findings. These are not ignored. And so the ID also looks at state capture matters where recommendations were not made. It talks back to the point that Advocate de Kock made earlier, that we use the state capture recommendations as a point of reference, but state capture has to be dealt with in totality and not just in terms of the matters that might have been mentioned in the state capture report. We currently have 15 recommendations in terms of the intake process that would culminate in 7 cases. Of the 86 recommendations that are currently under investigation, that is 86 out of the 122 recommendations, they total 16 cases. And of those 86, 21 of those recommendations are enrolled in terms of criminal matters, honorable members, and they culminate in 6 cases. That is the feedback of the investigating directorate. I will hand over now, Honorable Chair and members, to my colleague from the SCCU. Thank you.
Thank you very much, Honorable Chairperson. Thank you very much, Advocate Johnson. Advocate Beloy, are you ready to proceed? I think Advocate Beloy may have some challenges with the connection. I will then just proceed in the interim. As far as the SCCU work is concerned, and the committee should just bear in mind that we work in collaboration with each other through the Directorate of Priority Crimes Investigation. Many of the investigators currently assigned to the ID are from the DPCI, and those reports were presented earlier in this committee on the last occasion when the work of the DPCI was presented. So part of that work then reflects in the work of this Specialized Commercial Crimes Unit within the NPA, which is a separate component under a special director and through our directors of public prosecutions in the regions. So whereas the ID is a national component located in Pretoria, our Specialized Commercial Crimes Unit is the inverse. We have regional components that are focused on corruption work and on commercial work. And the SCCU is then coordinated at the national office of the NPA through the head office, through the special director, with a small team of people that do the coordination. So the difference in the model is that at the national level, the SCCU does not prosecute. The prosecutions happen in the regions, but the SCCU plays a strategic and a coordination role in terms of the work that we do. So currently, there are 44 state capture cases being managed through the SCCU at the national and through our provinces. And we try to ensure that the work that's happening in our provinces, most of the matters are located in Gauteng, in Free State, some in KZN. We then ensure that that work is getting sufficient attention. Out of the 44 matters in the SCCU that is being investigated by the Directorate of Priority Crimes Investigation, 2 of those matters have been finalized in court. The other matters are still under investigation to ensure that those cases are enrolled. The rest of the infographic provides the information in relation to the other state capture corruption work that we spoke about earlier, that does not necessarily speak to the Zondo Commission report. So I'm not going to go into detail of that. If we can move to the next page. In terms of the overview of progress of the SCCU, we just indicate again the manner in which the SCCU has coordinated itself. We have what we call the weekly case management meetings, where progress on our priority cases are discussed, coordinated, and taskings are given to ensure that the work is progressing. We've created and established an advisory panel. This is a panel of experts, of prosecutors, different prosecutors from time to time, with specialized investigators, where we are able to provide a mechanism where cases can be discussed in a very privileged and closed way, to understand what progress is being made, what the challenges are, to give advice on evidence, etc. So those advisory panels are functioning, and they are also assisting to ensure that our Zondo Commission work is being fast-tracked. We do have other meetings that speak to prioritization, and those are reflected. The MPCOC, just to highlight, is the National Priority Crimes Operational Committee, and this is coordinated by the head of the DPCI as the chair of the committee. We all participate, the national director, other heads of key law enforcement participate, and these meetings happen on a monthly basis. Here, all the priority work, including organized crime, corruption, and commercial work, are coordinated through the structure. And just to remind the committee that this structure is located within the Directorate of Priority Crimes legislation that is in part of the SAPS Act. And so the structure is created within that legislation. We ensure that there's prosecutor-guided investigations through all the work in the key investigations that we are busy with. And then it involves all the critical role players, as we've described before. An interesting methodology that we are now also exploring further is to ensure that we can co-locate our key teams who are working on these big cases, that we can co-locate them. We have found a suitable space for the colleagues of the DPCI and prosecutors to meet on a regular basis, so that the bigger cases, the bigger investigations, the teams are able to work together, and when they need to be in each other's company to discuss progress, etc., that we have created the space for them to do that. So that co-location process is something that we're also building upon. And just to remind the committee, we have reported on this before. As at December 2019, there were only 117 legal staff or prosecutors, lawyers in the SCCU. By July 2023, we have enhanced our capacity to 226 prosecutors and legal staff within the SCCU. Chair, I will now invite Advocate Ngoko to please then proceed with the part of the presentation in relation to the asset forfeiture unit. Lulama, are you ready? Ms. Mkeke, can you please indicate if Lulama is on the platform, if she's available to do the presentation?
I am, Advocate Dikok. Can you hear me?
All right, I can hear you. You just need to switch off one of those laptops in the room where you are. And please put on your mic so that the honorable members can see you. Thank you. Your mic and your video.
Okay. Oh, so you can hear me, Advocate Dikok? Oh,
we can hear you. Can you please put on your video?
And switch on. Am I visible? Oh.
Unfortunately, you're not visible.
The connection is very unstable this side, so
okay. But you are visible.
Let me speak. Oh, yes. Visible.
You are visible. You can proceed.
Apologies for that. The connection is, the network is very unstable in the office. So I tried to connect on my phone. That's why there was the feedback. Good morning, Honorable Chair, to the committee members and the NPA colleagues. I'll try and be very quick with the presentation so that if there's any connectivity problems, I would have then covered the presentations. It's not a lot of slides. The members are aware, of the sole purpose of AFU which is about taking the profit out of crime, obviously using the POCA legislation, which is the Prevention of Organized Crime Act. The Zondo Commission tasked ARFU with implementing recovery measures to address the consequences of state capture. And from there were 27 recommendations from the Zondo Commission report, which related to recoveries to be undertaken not only by ARFU, but also your SIU and other entities that are responsible for asset recoveries, for example, your SARS. But just to note that beyond these 27 recommendations from the Zondo Commission report, ARFU continues to monitor all state capture cases that are undertaken by, for example, the ID, the SCCU, the SIU, to determine whether there are any asset recovery potential in those cases. So we haven't only focused on the 27 recommendations. We've gone beyond that in partnering with our partners to see if there's any asset recovery potential in other state capture cases. Success in the implementation of these state capture cases obviously depends on our stakeholders, the law enforcement, the DPCI, and I'll touch a bit more on that in the next slide. Next slide, please. Next slide, please. Hello, am I audible, Chair?
Sorry, Lulama, my apologies. I've got the summary of asset recoveries to date on the screen. That's the slide 13 I'm flighting.
Thank you very much. Thank you very much, Florentia. Yeah, thank you very much, Florentia. That is the slide. The slide is self-explanatory, but just pinpoint key areas is that prior to the... Thank you, that is fine, Florentia. Prior to the Zondo Commission report being released, ARFU had acted on the 2016-2017 State of Capture report by Advocate Thuli Madonsela, and under that, ARFU recovered approximately 2 billion in state capture funds and assets, which were then repaid to victims. And post the release of the Zondo Commission to date, ARFU, in cooperation with internal stakeholders, other stakeholders, have recovered 14 billion state capture. Slide 53 to 55.
Maybe you must switch off your video.
Lulama, can you switch off your video, please, Lulama?
Can you proceed, Advocate Kok, with the presentation?
Sorry, Chair, my mic was off. So to proceed then, the previous slide dealt with the total actual recoveries and confiscation orders that have been obtained to the value of 2.97 billion and recoveries to the value of 5.4 billion, and the restraints related to 14 billion. Some of the work in the next slide on page 14, if we can move to that slide. This is a breakdown of the focus of the work of the AFU currently.
Apologies, Advocate Kok.
Okay, are you back?
Yes, I am. I'm using my phone.
All right, thank you.
Yes.
All right.
Florentia,
Just
apologies for that, Advocate de Kock, committee members. Florentia, if you could please go back to slide 13 under summary of asset recoveries to date. Thank you very much. Just to indicate, Chair and the committee members, at the bottom where it states asset recovery interventions, that portion addresses what in our AFU's asset recovery strategy, what we saw as a business unusual that was required in order to effectively address corruption cases. So specifically, you'll see that the critical interventions that are mentioned there, the Chapter 6 asset recoveries, and this is Chapter 6 under POCA. Why Chapter 6? There is a lower burden of proof under Chapter 6. So the view was that use of Chapter 6 in the corruption matter will ensure that we fast-track cases, also obviously in your money laundering and organized crime cases, which is not what we're about here. But Chapter 6 was one of the intervention. It's nothing new, but it is a critical intervention which requires obviously the support of our partners in terms of financial investigations, financial flows. Another critical intervention that was mentioned in the introduction by Advocate de Kock is the one that deals with international asset recoveries, because we were mindful of the fact that we would require the support of service providers that are keenly familiar with the international legislation as it relates to asset recoveries. And this is after the realization from the Zondo Commission report, which shows that there were monies that were moved to international jurisdiction. So it was critical for us to then get the services of international service providers who would assist and support us in this regard. Professional enablers was also another critical intervention, and Advocate Johnson spoke in detail regarding that. We are one of the partners in that respect. Advocate Johnson also mentioned the importance of corporate alternative dispute resolution, and this is something, an aspect that AFU is also very much involved in terms of fast-tracking corruption cases involving corporates, obviously under strict principles, guidelines that are put in place. And then the last intervention that we view as critical is legislative amendments, because in some instances, legislative provisions assist in terms of fast-tracking asset recoveries instead of going in. For example, the unexplained a provision is something that we're looking into as it relates to Chapter 6. We've got it under Chapter 5 of POCA, but under Chapter 6, we are looking at bringing into play unexplained wealth provisions in there in order to fast-track asset recoveries. If we can go to the next slide, please, Florentia. This slide really looks at the fact that high-level breakdown, there's an estimation that around or over 7.3 billion was disbursed by organs of state. And this slide basically looks at where the biggest chunk of those corrupt monies went into, and also speaks to who in the law enforcement arena is dealing with those asset recoveries. This goes back to where we were saying that AFU is not only looking at the 27 recommendations from Zondo, but looking at all areas where asset recoveries are possible, but also mindful of the fact that we are not the only ones who are conducting or are participating in this asset recovery space. So there it speaks to the role that is being played by SARS under the regiment, which I'm sure the members are aware of, and also the locomotive case and the fact that I think SIU is involved in settlement of that one. So that basically looks at the bigger picture. The next slide, please, Florentia. So this slide is the one that links up to our asset recovery strategy, where we're saying, where do we take asset recoveries in the future, bearing in mind that monies have been moved to international jurisdiction, bearing in mind that the corporates who were involved or implicated in state capture corruption. So moving beyond the 27 recommendations, we, for example, are saying that in some cases we'll have to look at cases that were not before the tribunal. The example is the OCM case, which is known as the mine case. I'm sure members are also aware of that. And then beyond that, looking at corporate alternative dispute resolution, looking at, again, the use of Chapter 6 asset recoveries to support other law enforcement agencies. And eventually, we're also looking at Chapter 5 asset recoveries. These are the conviction-based asset recoveries where we have to wait for the prosecution's case to be finalized, a guilty finding, and only then can asset recovery happen. So that is also in our arsenal in terms of what is the future, because some cases, by virtue of the evidence that is required in criminal cases, would take a while. So that slide speaks to that. And then the last slide is not my slide. Let me hand over to Advocate de Kock.
Thank you very much, Ms. Ngogo, for that. And thank you, Honorable Chair, for patience in terms of our connecting challenges. We have been experiencing challenges. I think it is as a result of the load shedding that has hit us both in Pretoria and in Cape Town. So just some concluding remarks from our side. Firstly, we submit that the NPA has laid a solid foundation in dealing with complex corruption cases. A lot of work is happening in this regard, and cases are being enrolled. We anticipate that in the new year, many more cases will be enrolled. And as I indicated in the introduction, this work is being managed on a priority basis, and a lot of energy and effort is being put into this work to ensure that the cases get onto the court rolls so that we can hold those responsible for the damage caused to our fiscus, for the damage caused to our country, to our democracy, accountable. And we want to submit as the prosecuting authority that the commitment of the prosecutors and the lawyers assigned to this work is 100%, that we are doing all in our power to ensure that these cases are in courts as soon as possible. We are now also moving to addressing these matters through prosecution-led investigations. So we also want to ensure that those cases and the most complex work is being managed through the investigating directorate and through the legislation that is being tabled in Parliament. We trust that our hand in this regard will be strengthened so that the work can be prioritized on a much speedier basis. The gains that has been made possible by previous budget allocations through the work of this committee and the support of the Minister and also through the support of the Treasury is valued. We note that currently there is a limitation in terms of our budgets, but hopefully this will be addressed in the not too distant future. The MPA is pursuing bold and innovative ways to work with our partners and stakeholders to consolidate the gains that we have made thus far. We recall, and we've reported on this before, the approach of the joint initiative between the Presidency and Business for South Africa, the work stream on crime and corruption. The MPA is critically involved, and through our strategy, operations and compliance unit under Advocate du Plessis, they take a critical responsibility to ensure that this work is fast-tracked. So that is still work in progress, but we trust that within the near future, fruits will be benefited from the work that is happening through this initiative of the President. The IDAC the Investigating Directorate Against Corruption, will be our most powerful weapon within the NPA to deal with corruption as soon as it is established, with its permanence and criminal investigative powers. And we submit that the IRD should not be hampered in terms of the work that it has to do. We are grateful for the support of the committee thus far, for the support of the Minister, and for the support of the Department of Justice to ensure that this legislation receives all the necessary attention. Committee and Honourable Chair, that is the presentation of the Prosecuting Authority. As I've indicated earlier, there is an annexure to this that provides much more detail. Lolama, can you just switch off your camera, please? Much more detail. And we are open to questions on any aspect of the presentation and the report and annexure that we have presented to Parliament. Thank you very much for the opportunity and for your patience during this presentation.
Thank you very much, ma'am, Advocate Cook and your team. Members, we have received the presentation. Are there any questions or comments? Advocate Breitenbach, Honorable Janji, Honorable Mkhwebane, in that order.
Thank you, Chair. Good morning to everybody. Chair, I have 4 or 5 pages of questions. I'll try not to ask them all, because if I do, we'll be here until this evening. At the outset, I just want to address the comment that Mr. de Kock made in his summary. That Advocate de Kock made in his summary, where he said matters are being fast-tracked. I want to point out to him that he cannot use that phrase anymore. The matters are not being fast-tracked. The NPA, that ship has sailed. The NPA is playing catch-up, and they're not catching up. So don't come to the committee and say these things are being fast-tracked. We're almost 10 years down the line. There's nothing fast about this tracking. I want to go back to the initial presentation, Chair. Rebuilding the National Prosecuting Authority, a lot has been done. I'd like to know more precisely, please, what has been done? What is being done, particularly what is the progress with regards to holding those people within the National Prosecuting Authority senior management who have been implicated in enabling state capture? How far are those matters? What is being done to deal with those people? We continue to hear that the matters are ongoing, that it's being dealt with. Well, today I'd like to know precisely where are we with those matters. We all know who they are. We all know where they are. We all know that they continue to undermine the National Prosecuting Authority, and you can never, ever heal your reputation while you keep them in your service. So today I'd like to know, what is the progress with those matters? I was going to ask you what has been done specifically to capacitate the specialized commercial crime units, but you've mentioned that you've increased the numbers to, well, quite significantly, but where have those people come from that have increased those numbers, and what is their level of experience? You mentioned that you're busy with 78 cases that amounts to 362 accused people. You know, this is problematic, as any lawyer will know. When you have multiple accused in a case, the case just never ever runs, because there's always somebody who's got an ingrown toenail or somebody who's got a cold, and matters just keep getting postponed and postponed and postponed because accused are not present. So what is being done to manage that aspect? And I'm not pretending for one moment that I think it's easy. I know it isn't. But what is being done to manage that aspect? And then there's an aspect that concerns me. Section 105A of the Criminal Procedure Act certainly allows for a very strategic use of obtaining information from potential accused or accused. I don't see this section being used optimally in these matters. Is it being used? And if not, could you explain to me, please, why it's not being optimally used? It's an exceptionally useful tool. With regards to the freezing and recovering of assets, yes, it's not been bad. It's a little ray of hope that some money has been frozen, some money has been recovered. I think we can all admit that, again, in the bigger picture, bigger scheme of things, the amount of money that's gone certainly isn't, enough to pop the champagne just yet. On the other hand, I think that South Africans generally would prefer to see accountability, people being held accountable, and not so much of money being recovered. They want to see people being convicted and going to prison. Then Advocate de Kock mentions again that the narrative that the National Prosecuting Authority is doing nothing is both not true and dangerous. Well, yes, it's not necessarily true, although whether they're doing enough or not is very debatable. But that they're doing nothing is not true. And every now and then we see a conviction and a prison sentence, which I try very hard to acknowledge and send to whoever achieved it a note. So yes, we see that they're not doing nothing, and we see that they are making inroads, albeit, in my view, not big enough and not enough. But to say that it's a dangerous narrative, the NPA has itself to thank for that. The way to stop that narrative, and I've said this before, and I'll continue to say it until they actually do it, the way to stop that narrative is to achieve convictions. Arrest people who are responsible for these crimes, prosecute them successfully, and send them to prison. And then that narrative will die all by itself. And you don't even have to do all of the cases. I can tell you that one or two big matters successfully prosecuted will quieten your critics quite considerably. So, don't tell us about dangerous narratives. Spend your time getting convictions. The NPA has to date prosecuted 3 matters, 2 ended with a conviction. That's a pretty good percentage rate. That's certainly nice, but I think we can all agree that 2 is not enough, not even close to enough. Again, the prosecutor-led investigations, Advocate Kock, you and I both know that this is as old as the hills. It's always been the case. It was the case with the Office for Serious Economic Offences. It was what the DSO and the SCCU were built on. So it's not a new strategy. It's a very successful strategy, I agree. The question must be why it hasn't been done constantly throughout the time, because that is the only way to deal with these matters, and we all know it. Then on your one slide, I forget the slide number, you mentioned that the expanded use of seasoned advocates and other experts to support the specialist prosecutions has been applied in some key cases already, and we hope to see some results. Yes, what kind of cases are these experts and seasoned advocates being used for? On what basis are on what basis is the outsourcing being done? And what has happened to the seasoned advocates, because there are still some, what has happened to the seasoned advocates within the National Prosecuting Authority who should be prosecuting these cases? Surely there's nobody in South Africa more seasoned and more of a specialist than a prosecutor with 20 to 30 years worth of experience at the job. That's what prosecutors are. They're expert criminal litigants. If they're not that, then what are they? And so where are these prosecutors, and why are they not leading these prosecutions? And again, there are some, and I don't see them. When you say that you have capacitated when you refer to the permanent ID, now you and I both know, Advocate Cook, that the ID being permanent will be a permanent in inverted commas, because it will not be permanent at all. So there's no point in putting more stock in this flimsy piece of legislation that we're going to discuss after lunch than it deserves. It will not be permanent. It will be a pseudo-permanent ID. Where will the skills come from that you intend to recruit to capacitate this unit? With regards to the backlog and the court roll, I hold the view, and I'd like your opinion on it. Please, Mr. de Kock, you must be one of the most experienced prosecutors in South Africa at the moment. Case roll management belongs with the prosecution, in my view. And we didn't have these problems with backlogs that we see now when the prosecution dealt with case roll management. Is it not time to have a discussion with the judiciary and return that aspect to the prosecution? Again, prosecutors are expert criminal litigants, and they know how to load a court roll. So that time is not wasted, so that court time is used optimally. And this doesn't seem to be the case. So is it not time to have that conversation? I notice with some measure of concern that the SCCU has a backlog of 865 cases. For a unit that was put together specifically to deal with specialized commercial crime and has its own courts. Each unit has its own court to deal with specialized commercial crime. This backlog is somewhat concerning, and we'll have to keep an eye on it because it needs to come down. Then I'll skip over a whole lot of other questions that I have and move on to the FATF issues. We all know why we were grey listed, and we all know that FATF was of the view that money laundering cases relating to state capture had not been sufficiently pursued. So not a lot has changed with regards to that. And grey listing will come up for discussion again soon. How do you propose to improve our position somewhat significantly with regards to showing some progress there? Cases referred by the SCCU are not dealt with expeditiously. Well, yes, they have their own tribunal. They can deal with some of the matters. Traditionally, the SIU cases would go to the SCCU. Are these the cases that are making up their backlog? And if so, why are they not being dealt with? And then I'd like to know from the asset forfeiture unit, what precisely is being done to facilitate the recovery of money from overseas jurisdictions. And I get the problems that go along with that, and I get the expense involved. But what is our plan there, please? Thank you, Mr. Chair. I'll stop there for the moment.
Thank you, Honorable Breitenbach. Honorable Janche.
Nkosi Sihlalo, and thank you very much. Let me also thank Mr. de Kock standing in for Ms. Shamila Batoy for this comprehensive presentation that took almost an hour. Very good work that you're presenting. I would have been covered in a number of areas by Honorable Breitenbach. I'll emphasize few of those just to raise the issues that I kind of picked up. I think it's worth noting that this presentation does demonstrate that there's a lot of work that the NPA is doing. We're able to see the results. But it's also worth noting that from the presentation, there are certain areas where you are not able to indicate to us in a very demonstrable way what is it that you're doing to overcome some of the challenges that you are presenting. Because the last thing we want is for you to come and present a diagnosis to this committee of the kind of things that you are dealing with, which show in the main more kind of problems than how you're succeeding in the solutions. And I want to raise that the first part, you have raised the issue of limited capacity in relation to the matter of the integrated task force. I've not heard you dealing with how you want to overcome, how you're planning to improve that situation of limited capacity. But secondly, and the most important thing for me, Chair, which lacks any alternative plan that you are putting forward. You have been correctly able to identify that there is a problem in terms of the congestion of court rolls. It's a big problem. It's like a funnel. You put everything else in the funnel, but nothing comes out of the funnel. And unless you open that up, you're not going to, you can do anything else. But if you don't do that, you might not even reach your targets in your asset for future strategy, because that comes out as a result of you succeeding in the court rolls. And so you've got that congestion. I was hoping, and maybe that's what you need to share. You have not shared with us what is your thinking, what is the alternative plan to deal with that court roll congestion? Are there things that you are taking up with the authorities that you want to share with us in terms of the kind of assistance? You've painted a very gloom picture, and the numbers later on in terms of the outstanding cases demonstrate that. You have 1,505 on court rolls. That's a big number on court rolls. Honorable Breitenbach raised this 865 cases in the SSU, 921 corruption cases on court roll. Now, you can see where the blockage is, and yet you're not able to put forward how you are tackling that in a form of a very systematic, planned program of intervention, and be able to point out where assistance is needed. Unless you attend to that and give us some of your thinking. Are you thinking of, as Honorable Breitenbach raised, that you get into some discussion about how the NPA can be anchoring that space and leading that process in order to loosen up that space? Or are there other alternative plans that you can share with us that will assist you in dealing with that? That for me is very critical, and I would like to hear how you respond to that. You have increased your legal staff, 117 to 226. I'm interested you've mentioned prosecutors and lawyers. What are the other skills that you have in these 226? The kind of a background breakdown might not even give us here. If we're able to share that, it will be very much important. And then likewise with Honorable Breitenbach, the enablers of state capture. You've spoken about 2 matters that involved 60 enablers. I would like you to elaborate on that. Are you in a position to share with us in specific terms, what are we talking about here? Who's this, and what are the kind of interventions? Because we're not just interested in those that were in the forefront. We're very much interested in the masterminds of this entire process. And that, for me, speaks to the enablers of the state capture. But lastly, Chair, it will be important, as Honorable Breitenbach indicates, that for each of those backlogs, the big numbers, it would help that you share with us what is the targeted intervention, what is the plan to reduce this backlog. I would be very much at ease if you say to us, we've got 1,505 on court rolls, this is what we want to do, this is the plan, 865, this is how we're who are dealing with it in order to reduce that and so on. Unless we hear that kind of presentation and intervention, you, as well as just ticking the box, operating on a lotto approach and only just clapping hands when there's one or two cases that you have breakthrough on, whereas you could be very much systematic and create a momentum of dealing with these kind of issues. Those are the few points I wanted to raise, Chair. Thank you very much.
Thank you, Honorable Janji. Honorable Mkhwebane.
Thank you, Chairperson. Good morning to everyone. Thank you, Chairperson. Thank you to the team for the presentation. Chairperson, my questions, some of them have been asked or addressed by the two members who were before me. But then my first question relates to the explanation which I would want to hear from the management of NPA. What, and even that task force which you have, because all structures are sitting there, and when you decide that, okay, this case is ready now, we are taking it to court, we need to arrest and the person must appear, then all of a sudden the person is appearing before court, there's lots of postponements, and the charge sheet is not even ready. That's very much embarrassing, to say the least, because why rush to arrest and a person is appearing before court? Then you find the matter is dragging for 2-3 years without the proper charge sheet, without the person being charged. I think that as well taints the image and the narration which is going out there to say the NPA and the law enforcement in South Africa is just useless, because, and you are being accused that you are being political or playing in political spaces because you would identify certain individuals and just follow up on them. The second issue which you need to clarify for me is they said, out of the cases which I would say corruption cases which came out or which were identified, indeed it's true that the Zondo report is not binding, but then it's a document which you can go back and refer, and it's like a lead document for you. But then what is the success, or what is the case where you'd say we have evidence, we have prosecuted successfully, besides cases, because I saw the reports or the attachments which you've shared. There's one case of Dudumieni, how she behaved at the commission, and that you are mentioning as a conviction. I mean, I'm referring to cases where there's allegations that there's corruption, there's proof, this is the money which we've managed to trace and we followed the money. Indeed, this is our success, instead of what happened with the Nulani case, where it was also one of the things where you rushed and the matter was thrown out. Yes, it's before court. And the issue of ABB, are you not yourself promoting corruption? What kind of which legal framework are you relying on as South Africa? Which provision? Because I've seen the NPA statement about this arrangement settlement, and just mentioning POCA section 64E, which is not the correct as well reference. Which provision you relied on? Not your departmental guidelines and SOPs, but then the legal provision in South Africa, where you would say, ABB, yes, you are upfront, you are willing to pay back the 2.5 billion, you've paid 1.5 to ESCOM, but a crime is a crime, and you say we are not prosecuting you. So it means this is just an favoritism on which you are doing. If you are rich in the world, therefore you will not be prosecuted. Because in South Africa, we don't have that provision. If you can just indicate which law did you utilize in South Africa. In other countries, in their laws, for instance, the US, they would have that provision where if you acknowledge and we agree, we enter into a settlement for naught. So that alternative dispute resolution, was it not meant to deal with backlog cases, and so that you don't clog the case load with the matters which you can resolve quickly, and cases which are not as involved and as complex as this one? So is this not a contravention of the very same Prevention and Combating of Corrupt Activities? Because in South Africa, there's no legal mechanism unless you mention which section you relied on in that. Because I've gone through, that's a settlement agreement, and unfortunately, it only refers to the departmental guidelines. It doesn't specifically relate to which section you rely on to conduct such. So I would say then this is very much concerning. Then the issue of the backlogs, my colleagues, the other members have dealt with, but then I think it would be very critical for you to just give us the strategy. I understand as well that within the department, there is the National Efficiency and Enhancement Committees and the Provincial and Efficiency and Enhancement Committees, whether indeed those also assist in dealing with the corruption-related crimes. Because, I mean, corruption is just corruption, and I think we just need to deal with it as that. And I think we cannot even postpone doing our work because we are waiting for some legislation, as Honorable Breitenbach is saying. But then currently, what are we doing to make sure that we deal with matters expediently, and we bring and agree to take matters to court on matters where you have evidence, on matters which you will deal with, so that you can do away with this perception which sounds to be true, because it's still continuing. Thank you, Chairperson.
Thank you, Honorable Maseko Chele.
Thank you very much, Chairperson, and good morning to the colleagues and also to the Advocate de Kock and the team. Chair, I think I've been covered in so many ways by my colleagues, but I'll just emphasize on the issue of Chair. I just want, in fact, I'll just indicate few questions, particularly on the issues of capacity. I want to find out from the Advocate de Kock as to how are they dealing with, how are they bringing balance between the two cases of the TRC and the issues of state capture. Because, Chair, I think I'm saying that in relation with the capacity that they have, I just heard one of the presenters saying they are now also following with that energy, following those matters of the state capture with those without recommendations. Whilst we are still expecting the very same, I understand, Chair, I'm not saying they must not follow that, but also that talks to the capacity that they have as an institution, because there are still other matters that would like them to put energy as they are doing also on the state capture. I'm not against them doing the issue of state capture, but we still have matters of the TRC, Chair, that we are dealing with, that we need them to follow them with the same energy. Because right now, Chair, there is on this issue of the TRC, there is also this view, or it's just an allegation that is coming, we don't know, because maybe still coming, that some of the families are now about to sue the state on those matters, Chair, because those people who were involved are dying. So I'm saying, Chair, the same vigor that we are using in following up the state capture, it should also be used in making sure that the issues of the TRC are being attended to. so much, Chair. We had on their previous report, not long, Chair, November, they indicated that they have lost some of their dedicated investigators. They mentioned, for example, Chair, reduction on, like they were having 25 prosecutors, they have been reduced to 15, and then
I think, to be fair to them, that presentation is still coming specifically on the TRC. I think we can reserve that part of the question to.
Let me just talk about only the balance, Chair. Let me just leave that
Sure.
one on the issue of the balance. How do they bring balance on these two issues? Thank you, Chair.
Thank you very much. Thank you, Honorable Jelle. Advocate de Kock, I think there were quite a number of questions that were asked. Maybe it's time to take a 15 minutes break so that you can also allocate the questions amongst yourself. Can we take a comfort break for 15 minutes? We'll come back at 11:15. It will be 20. Yeah, 11:15.
Thank you, Chairperson.
Thank you.
I think the people sitting in the meeting. Just a minute, just let me. Hold on.
Can we start? Advocate de Kok, over to you.
Thank you very much, Chairperson and honorable members of the committee. I may add that I did have some serious challenges with my connection. My laptop died in the process. So if at the end, Chairperson, I've missed any of the questions, please just remind us which ones those are. What we have done is we've arranged ourselves in a particular order. I will ask Advocate du Plessis, Deputy National Director of Public Prosecutions responsible for strategy, operations and compliance, to first deal with the questions relating to labor, the questions relating to resourcing, capacitation, and the private-public partnerships that the NPA has entered into. Then I'll ask the investigating director, Advocate Johnson, to deal with the questions relating to the work of the ID. I will then ask the head of the SSCU, Advocate Beloy, to respond to any question relating to the SSCU, and then Advocate Ngoko will respond to the questions relating to the Asset Forfeit Unit, and I will deal with the questions in the end. So at this stage then, I hand over to Advocate du Plessis. Thank you.
Thank you very much, and good morning, Chair and honourable members. I'll take the for Honourable Breitenbach. I think the first one is a broader question about this narrative of the NPA's response to state capture, and what we say that the narrative that nothing's happening is both wrong and dangerous, and then what's being done to rebuild the NPA. So just to make the point, Honourable Breitenbach, we're not saying that the NPA has moved as fast as it would have wanted to, or that enough cases have been brought before court. One of the reasons we say it's dangerous is if you look at international benchmarking, the NPA, these are highly complex matters of corruption and related crimes that rely predominantly on digital evidence. And all over the world, these cases take many years to finalize. I think the fact that we've brought 34 of them that have been enrolled before courts just through the ID alone, and over 100 through the SCCU, I think that is significant progress. And what we don't want to be in a situation is where the narrative is created that these cases that can be dealt with quickly and swiftly, or that the Zondo Commission provided a blueprint for that to happen, because that creates unrealistic expectations that is dangerous for the rule of law. And that's why we say it's dangerous, because all over the world, these cases take time. And I think if you look at the balance of progress that's been made, I fully agree with Advocate Breitenbach. One big case, one big conviction will shift that narrative in our favor. But I think it's important to get that balance right, both for the public, but also for prosecutors in the NPA, because we can't be beholden to this pressure. Because if we are, and we bring cases that are not ready, or we bring cases that are not passing the standards that we have to pass in terms of bringing these matters to court, that can be very problematic. And we have to act, as you know, without fear, favor, or prejudice, and be perceived to be doing so. And these cases do take time. On what's being done to rebuild the NPA, I think it's also important to recognize that while the focus of much of the media attention, and indeed this session before the committee, is about state capture matters, that is a drop in the ocean in the context of what the NPA deals with on an annual basis. We live in one of the most violent crime-ridden countries in the world, and the NPA deals with about 650,000 very serious criminal matters on its roll every single year, and it does so quite well if you look at our conviction rates. And that doesn't happen by default. There's a lot of work that's gone into making sure the NPA can deliver on its mandate. And if you look at our overall performance, despite challenges along the way, in the last couple of years, we've significantly improved. So what has been done to build the NPA, rebuild the NPA, as the Honourable Breitenbach says? Well, first, we must recognize that it took almost 10 years to bring the NPA to the position it was in. We had great people left in the NPA, but the leadership was decimated, the morale was decimated, there'd been no recruitment, no appointment, no training, the structures were in disarray, and the National Director started in 2019, and a year later, COVID hit. So if you really look at the rebuilding time, we're looking at about 2.5 years when the NPA's full leadership was appointed, and I think that's a significant step towards rebuilding. We appointed several DPPs across our provinces, most of them women. We appointed the top leadership of the NPA, because remember, the National Director started with basically having to rebuild its leadership team. And I think that's an important step, especially if you consider that the leadership of the NPA, I think, is more independent today than it's ever been. If you look at the process for the appointment of the national director, which was important, if you look at the discussions that have gone around the reform of the NPA Act, I think the NPA leadership is not beholden to anyone. And I think the public in South Africa might be frustrated at the lack of progress, but I don't think there are too many people questioning whether the NPA's leadership is not independent. And I think that's an important step towards rebuilding. The second thing we did was we went on a massive recruitment drive. And for years, there'd been no budget allocation and no recruitment in the NPA. And we were able to appoint a significant number of new prosecutors into the NPA. And that also just happened by default. There's a lot of work that went into getting that done. It's a hugely significant component of the rebuilding. We didn't just appoint people. We also embarked on an extensive capacity building program, partnering with international organizations and other partners to make sure that our prosecutors were properly trained. And we've reported to Parliament many times on these initiatives, so I won't necessarily repeat them, but it's not just about appointing people. It's also about training them. Speaking about those 650,000 cases, a big component of those cases has been the sort of horrendous nature of the sexual and gender-based violence in the country. And South Africa's, the NPA has done a huge amount of work in continuing to be trailblazers in how we deal with sexual and gender-based violence. We've moved from 55 TCC centers to 63 now. We've appointed a number of new staff and additional capacity into those centers. And then also we've appointed community prosecutors in 45 centers across the country. Chair, I could go on. There are many examples of this rebuilding, but I think what's important to recognize also is that the efforts behind the scenes to create a professional organization of 5,000 people, that's not what the media is interested in. That's not going to grab the headlines. But you can't have an organization that was as decimated as it was during the state capture years, getting to where it is, reporting as accurately as it does, and running as professionally as it does, without a significant amount of rebuilding work. And the leadership of the NPA, I think, has a lot to be proud of there. And these are not things we speak about in the media. And the media is not going to report on the reform of our internal policy processes, the fact that we've now got a unqualified audit on our finances. All of those things are an example of the rebuilding that's taken place. And I'm happy to answer more questions on that. But I'll move on to the second point that was raised by Honorable Breitenbach, and that's the question of prosecution-led investigations. I don't think we should confuse prosecution-led and prosecution-guided investigations. I would agree that prosecution-guided investigations have been around for a long time and is an international best practice. And that's exactly what we do within the SCCU environment. That's where prosecutors work with their counterparts in law enforcement, and they guide those investigations while everyone stays in their own lanes and reports to their own bosses. Prosecution-led investigation is something different, which is what we have been pushing for with the IDAC bill, which is essentially what the DSO had, but it's what the NPA hasn't had for a long time. And that's why we're so excited about this new bill, which will bring back a prosecution-led investigation or PLI approach to our work in the context of complex corruption matters. That is the game changer we've been speaking about. And it takes us one step further than PGI, which is prosecution-guided. And really, that is the gold standard, I think, when it comes to prosecuting complex organized crime and corruption matters. And that's why we've been pushing so hard for it over the last 2 years, and we're quite excited. So that's on the PGI thing. I just want to come back to this question of the permanence of the ID as well.
Sorry, Advocate. You
Yes,
are
sir.
not only to members of Parliament. You are also talking to the broader public. I think it would be better to just briefly explain the difference to
Sure.
an ordinary person. What is the difference between prosecutor-led investigation and guided investigation?
Thank you, Chair. That's a good point. Yeah, so prosecution-guided investigations is the model when you bring multidisciplinary teams together, as we do in our SCCU model, where we work with the police, we work with our other law enforcement partners, and we guide them in the context of a prosecution strategy. And that's the international sort of approach to complex crime. Prosecution-led investigation is one step further than that, which is where the prosecution authority actually employs its own investigators with their own criminal investigative powers, which is what the new ID bill does. The investigative directorate will employ investigators and analysts that won't work for the police or won't report to the police, will have aligned performance indicators. They will report to the head of the investigating directorate. And that's why the term led is stronger than guided in the context of this approach. And that is really what's needed when you're dealing with the most complex versions of organized crime and corruption. And that's why, well, particularly state capture type corruption, which is why the prosecution-led model, which might come if the bill is adopted, is so important. I'm going to briefly speak on the question of the disciplinary processes. We have mentioned to the committee before that, of course, we can't discuss the individual nature of those cases. But I do want to reassure the committee and the public that those cases that Honourable Breitenbach refers to are very well advanced. The inquiries have begun. Unfortunately, the chairperson of the inquiry passed away in January, as we reported, and we had to start the process again. But those inquiries are very well underway. There are a number of colleagues that are currently before those inquiries, and we have to follow the prescripts there. These are not things we can short circuit. They're bargaining councils, they're labor unions, there's a whole range of processes involved, but they are very well advanced. And we spend a huge amount of time and attention making sure that those processes are run fairly and properly. There's also the one case of a DPP that, again, as you know, is not something the NPA decides on, but it's a matter that is with the president. Everything that needs to be submitted to the president has been submitted. We've got various legal opinions on it, and the president is applying his mind to that process and will decide whether a commission of inquiry needs to be established. Again, there's not much more the NPA can do about it at this stage, but just to reassure Honourable Breitenbach, we are very aware of the impact of these matters. We have to handle them fairly, we have to handle them impartially, and some of the cases we've handled, we have no ability to influence further than we have, because the president must decide. I want to come to the last question, if I may, Chair, it was Honourable Gianti that asked about what do we need to do to move forward from the situation where we don't have the capacity and the resources. I think Advocate de Kock will deal with the case flow backlogs, but I want to deal with that question of what do we need to do to move forward to get the capacity. The first thing we need, and we're very grateful for the support from this committee and from our minister on the budget over the last few years, and we're very aware of the fiscal constraints that face the country right now. But we need the additional budget to recruit the kinds of specialist skills that we need to bring into the NPA. We need to be able to recruit more prosecutors. We need to be able to keep our aspirant prosecutors program going, and that is going to require money. The NPA's budget is relatively small in the context of the broader criminal justice system. We're just over 5 billion. And we realize that the fiscal situation is dire, but we need that money. We need additional funding to appoint new people, to train the people we have, and to make sure that we build those skills. And it's not just about prosecutors. We also need to bring in proper management skills, project management skills into the NPA. And if we do get the new ID bill passed, of course, then we'll also have to bring in digital and forensic analysts that can support us. That's going to require money. We know in this context that's going to be difficult. Insofar as the fiscus can't provide that, we're going to have to be bold in how we partner. We already are doing that. We're partnering with organizations across the world. And we are looking at innovative partnerships with a range of entities to make sure we can get the skills that are needed into the NPA. Even if we can't get them in permanently now, we can look at other arrangements where we can bring in digital forensic analysts, still on our terms, making sure we protect our independence. But we're going to have to be bold in bringing in those skills. And we're going to have to rely on our partners to assist us with training. Across the world, prosecution authorities are struggling to deal with the complex nature of modern day crime, particularly the digital nature of the evidence. So we're going to have to really invest in that. I think over the next 5 years, that's going to require quite a huge investment of funds. But without that funding, it's going to be very difficult to deliver on that. But we can give more concrete examples, but that's really, for me, the crux of what's needed over the coming years. Thank you, Chair. I'll hand back to Advocate de Kock.
But if you said you need more money, do you know how much do you need? And what is the basis for it?
Yes, Chair. I think you will see from how we spend our budget every year, I think we spend our budget to the cent. So we're quite scientific in how we budget and in how we spend our money. We have provided detailed breakdowns of the amounts we need moving forward. Obviously, the costing around the ID, if it gets approved, will still need to be done with National Treasury. We've done the organizational design process, but we have put in our requests, and I can share those with the committee in writing. But we have it down to quite an accurate science in terms of what we would need over the coming 3 to 5 years in terms of getting the capacity that's needed to deal with these kinds of crimes. And it is quite an increase on our budget, Chair. would need, I would expect at least another about R1 billion over the next NTFF to be able to deliver at the level that we need to deliver. But again, we're fully aware of the constraints facing the fiscus, and we're really appreciative of the support that we have been given by our minister. That's the reality. This is an expensive business to be in if you want to succeed, and we simply will need to find that money over the coming years.
Thank you, Honorable Janje.
Maybe, Chair, let me not disturb you, then you can just bring me back for follow-up. I'm excited about what the last point you raised and your intervention. For now, maybe let me hold back.
Okay, thank you. Advocate de Kock.
And Chair, just on the last point as well, we've also clearly budgeted for our witness protection unit. And just the committee is aware that the witness protection unit is located within the National Prosecuting Authority. So a portion of our budget also goes to the protection of witnesses. And that's one of the areas that we've also motivated for increased budget in relation to. We take the issue of protection of witnesses very seriously. And over the recent events in our country, we need to strengthen our witness protection program. So just also to add, it's not just about the prosecutors and support staff, it's also about the witness protection as far as the budgets are concerned. I will then invite Advocate Johnson to take the next round. Thank you.
Thank you, Advocate de Kock. Honorable Chair and members, on a question posed by Advocate Breitenbach, albeit that it wasn't directly to the ID, but it is a relevant question in terms of Section 105A, that it is strategic getting use of information from accused without going into the details of matters, more so because they are part of a broader prosecution strategy. The ID has used Section 105A in October in a matter in the regional court, now in November in a matter in the High Court, with the view to getting Section 204 statements after persons have pleaded. And we have ensured, Honorable Breitenbach, that those that pleaded didn't just plead, but they also paid back the proceeds of their ill-gotten gains. So the ID is mindful of the strategy, and it is part of how we deal with the cases going forward. The Honorable Ndate Janke, on the enablers of state capture, what are we talking about? Are we talking about masterminds? Honorable Janke will appreciate that I cannot share details of names of individuals and entities. Safe to say that we are looking at those who caused the most harm to our constitutional democracy. And it includes, amongst others, as I indicated in that Janke, not just consultants and agents and lawyers, we're also looking at banks who were the enablers of state capture. And to indicate that the State Capture Commission, in fact, in its report, dealt with 17 such illicit flows. They are cross-cutting, looking at SOEs and at departments. So we are looking at a broad range of state capture enablers. The Honorable Mem Kwebane, with regards to the arrests, and I can speak, and I will speak only for the ID, the Advocate de Kock will deal with issues of the task force. When the ID considers its matters, Honorable Mkwebane, we follow the evidence. What we do is we do not work on targets. We have to follow the evidence. And at the stage of arrest, we arrest when we know that we have a prima facie case. I think in terms also of some of the postponements in the ID matters, we have ensured that when we go to court, we make sure we go with the draft charge sheet. We are in most instances, we are ready for disclosure. But what we also do is we have to be mindful that in many of these matters, there are several accused, and Honorable Mkwebane would appreciate that they also have issues of postponement because there are lots of legal representatives. There are lots of preliminary issues that must be dealt with. But at no stage does the state place a matter on the roll with the view to frustrating anyone and or the courts. And so when we do place those matters on the roll, Honorable Mkhwebane, we do place them on the basis that we are ready at the time those matters are enrolled. I will take the final question on the ADRM, the Alternate Dispute Resolution Mechanism, also asked by the Honorable Mkhwebane, just to indicate, honorable members, ADRM is a policy decision that has always been part of the prosecution policy of the NPA. In fact, it is as old as time, but it has not been used when it came to corporate entities. Almost invariably, these were dealt with in order to ensure that part of prosecution doesn't only mean prosecuting in terms of getting people on the court roll. There might be instances and circumstances where this isn't strategically the best option to follow. However, with ABB, the engagement and the negotiation was only with the entity. I am at pains to emphasize that the directors, persons on the board, other employees of ABB are not exempt from the prosecution. That is not part of the agreement. So the ADRM does not seek to indemnify any individuals, be they on the board, directorships, and or the employee. They are still and will be dealt with where there is evidence pointing to their criminality, honorable members. I think that deals with that issue. And Honorable Mkhwebane, there isn't a legal provision per se, but it is in terms of the prosecution policy of the NPA that we deal with alternate dispute resolution mechanisms. We do not have a non-trial resolution, as does the US DOJ, with whom we also engaged on the ABB matter, but they have a different, they have a legal provision. We are a policy decision and one that has been part of the NPA policy for quite some time. Honorable Chair and members, I thank you. Advocate de Kock, I hand back to you.
Thank you very much, Advocate Johnson. Honorable Chair, just to add to the last point on the ADR.
Advocate de Kock, we note your hand, Honorable Mkhwebane. We will prioritize you when we do the second round of questions.
Okay, Chair, it's fine, because Advocate de Kock is still dealing. I want to follow up on that issue of the ADR. Okay.
Sure.
Yes, just to add to the comment made by Advocate Johnson on the alternative dispute resolution mechanism, the ADRM. Just for the committee to note, I think we may have mentioned in a previous parliamentary report that the South African Law Commission is currently looking at the question of these plea arrangements, looking at the question of legislative reform in terms of this particular issue, dealing with alternative dispute resolution mechanisms. We have made a substantial recommendation, submitted a report to the Commission as well, and we encourage a legislative reform in this area. So hopefully in the new administration, this issue, and after receipt of the Commission report, we can interrogate this issue further and how to utilize these mechanisms in the best interest of the country and of the criminal justice system. I will ask then a Chair for Advocate Baloyi just to answer the question relating to the SCCU establishment, if she can please answer for the committee. Thank you.
Thank you very much, Advocate de Kock. Good morning, Honorable Chair and honorable members of the committee. And good morning also to the colleagues within the NPA who are on call currently. Now, in response to the questions posed to the Specialized Commercial Crime Unit, I will deal with the question which Honorable Breitenbach posed relating to the number of appointed prosecutors that has increased within the SCCU. The question being, where do these people come from and what is the level of their experience? Now, in response to the question, Chair, I would say that the better part of the prosecutors appointed within the Specialized Commercial Crime Unit are prosecutors within the National Prosecuting Authority, and that would be prosecutors from within the SCCU itself, prosecutors from the various directors of public prosecutions, and prosecutors who are also in our regional courts, who get promoted to deputy directors of public prosecution posts within the SCCU, as well as posts of senior state advocates. And in respect of the level of experience of those prosecutors who are appointed within the SCCU, I would say that they are required to have at least 10 years legal experience in prior to the appointment to those posts. And in addition to that, with the view to ensuring that we upskill the prosecutors within the SCCU and those who are appointed within the SCCU, we have a training forum which has a training plan that addresses various aspects of within the complex commercial crime space, such as cybercrime, cryptocurrency, money laundering, and this assists to ensure that our prosecutors in the SCCU are in the position to efficiently and effectively deal with the guiding of investigations of these cases, as well as their criminal prosecutions. Now, the other cases which was posed related to the backlog within the SCCC, the Specialized Commercial Crime Courts, which was reflected as 865 cases. And that in spite of having these courts, there are delays in the finalization of the cases. And I would say that one of the delays is caused by delaying tactics which are brought by the defense in the cases, interlocutory applications, but our prosecutors are directed to ensure that we oppose such applications, and they do oppose those applications to just ensure that the cases can move quicker and are finalized faster in addressing those delays. I want to also mention that in spite of having this high backlog of 865 cases, I can mention that during the period of COVID, we in fact had more than 1,000 backlog cases, which we had within the Specialized Commercial Crime Courts. And this has to date come down to now 865 cases which are under backlog. And amongst other issues which contingency plans that we put in place to ensure that our cases move quicker in courts is to make arrangements that trials, we have what we refer to as ongoing court rolls, whereby trials on the matters are held for a continuous period of time, other than where you have a trial scheduled for 2 to 3 days. And where we have ongoing court rolls, then we see that there is quicker movement in terms of the prosecution of the cases. And the other issue that was put in place to try and reduce the court rolls within the Specialized Commercial Crime Courts was collaboration through the Department of Justice, which assisted in ensuring that the specialized commercial crime courts in all the divisions, whereby we to date now have 22 courts, making it, that we have 8 more courts than we previously did. Thus, our cases are able to move a bit quicker than they did previously. There's also plans in place to have additional courts created for some of the divisions where we see a greater backlog of cases, and there are discussions in that regard within the steering committees which the SCCU sits in, and the Department of Justice chairs, where there are discussions in terms of, you know, where more resources in terms of additional courts can be created for the various divisions. I think that is all from my side, Chair, Advocate de Kock. Thank you very much.
Thank you very much, Advocate Baloyi. If we can then ask Advocate Ngoko to please proceed to answer the questions relating to the asset forfeiture unit. Thank you.
Thank you very much, Advocate de Kock. The question that was posed by Honorable Advocate Breitenbach was related to what the plans are that are in place in order to address international asset recoveries. So AFU has got an asset recovery strategy, and in that asset recovery strategy, we deal a great deal with what our approach will be with respect to international asset recoveries. I'll not go into detail, but safe to say that there's a two-pronged approach. There's the traditional approach of using ICMA. ICMA is the one that has to do with, you know, mutual legal assistance and the mutual administrative actions, where you link up with the law enforcement agencies in other countries, you do the formal processes through our Department of Justice. So that's the first approach, but we've realized that that approach has limitation in terms of speed within which the international countries respond to the MLAs. So the second pronged approach in this two-pronged approach is the use of specialized international legal and forensic service providers. Here we're talking about international legal service providers that have got experience in international asset recoveries. They know the laws of the countries, they know the processes, they know the procedures. What we have done is then appointed two of these international service providers to undertake international asset recoveries. And the benefits of that, as indicated, is around the fact that they are very much familiar with the laws in those countries. To date, without again going into detail, we have provided them with targets in terms of these are the people that have taken money out of South Africa. We've provided them with those targets, as well as provided them with 4 projects where in those projects they will engage in the tracing of the assets and getting into all the processes that are required internationally in order to deal with the asset recoveries that side. So in a nutshell, it's a two-pronged approach where we use the traditional methodology of ICMA, the mutual legal assistance, but also using international service providers in order to work in tandem with the traditional approach. I hope I've responded. Thank you, Advocate John. Advocate de Kock.
Thank you very much, Ms. Ngoko, and thank you, Chair. I will then attempt to finalize some of the outstanding questions that have been raised. I think under the questions asked by Ms. Breitenbach, she spoke about the challenge of multiple accused on our court rolls, and I think in that context also raised Section 105A and the optimal use of that. So it is a strategy of the prosecution. It's been a strategy for years, the effective use of 105A. Provision in the Criminal Procedure Act. But the committee is aware of those provisions. It's a very formal process. It needs to be recorded. The accused need to reflect all the elements of the offences to which the accused are pleading guilty, and we need to then propose a sentence to the court. So it is quite involved, and just in terms of our own jurisprudence, there are checks and balances in terms of the Section 105A process that I think we as a country we should be grateful for, because there's no chance that we can just rush through a Section 105A process in our courts. The court is the final arbiter, and the court needs to evaluate whether or not that accused has admitted all the elements of the offence, and whether or not the sentence is a just sentence in terms of the legislation that creates the framework. So we do use it, but it is dependent on an accused person wanting to engage with the state in relation to that. We cannot force it. And the law also requires that an accused person must be legally represented when they engage with the state or the prosecutor in relation to a plea and sentence agreement. So those that's the framework within which we work. We encourage it, and we encourage it particularly in matters of a complex nature, like our racketeering prosecutions and like the matters that we are now bringing to court in terms of the state capture. So the question is asked, the question that should be asked is, why do we have multiple accused in cases? And the answer to that question is really an indication of the complexity of crime in our country, because we are dealing with serious, complex criminality. More and more accused persons are then thus joined in one case because they are all involved in the criminality surrounding that case. Of course, some of the participants in that criminality play a lesser role than the main perpetrators. And our approach to that is, of course, that where we can and where it's in the interest of justice to do so, we do use some of those participants either as Section 204 witnesses, where they cooperate with the state and give evidence on behalf of the state, or in terms of Section 105A of the Criminal Procedure Act, where they plead guilty and where they then are willing to give evidence to the state. So those are strategic questions that have to be asked in every investigation and every prosecution in collaboration with a number of role players. So just to affirm again to the committee that is part of the strategy that the prosecution employs in dealing with this complex work. The other question that Advocate Breitenbach also spoke about is the use of other expert advocates or seasoned advocates, and what is the position with our own advocates. Well, we've just heard from the Special Director of the number of specialized commercial crimes cases on our court rolls. Our advocates are all fully occupied with many, many serious matters on our court rolls. Corruption is one feature of the criminality that we deal with. There are many other commercial matters that we deal with as well. And as we got an indication of the extent of the backlogs in the SSCU courts, just to confirm to the committee, because that's a regional court, the backlog definition is 9 months. So when a case is 9 months on the court roll and it moves over the 9-month mark, we monitor those cases very clearly. So here it's also appropriate just to expand a bit on backlogs. So how do we manage backlogs in the NPA? A case only becomes a backlog once it's enrolled. So the backlog is not in the environment of the prosecution. The backlog is in the environment of the court. And we must always bear in mind that the presiding officer, the judge or the magistrate, is responsible for the management of the work in a court. The prosecution, once a case is enrolled, becomes a litigant in that court process. So our role is to assist the court to ensure that that backlog is managed as best as possible. And that is what we do. We do it in the court environment. We do it at the managerial environment at a local level. We do it at the provincial level, where our directors of public prosecutions has the responsibility to do this, with the judge presidents in each of our divisions, and that's through the so-called Provincial Efficiency Enhancement Committee. They're supposed to reflect on the state of the court rolls. and then understand how best we can manage those court roles so that we can reduce those backlogs. And then at a national level, when we do meet with the Chief Justice, those issues that cannot be resolved at the provincial level is then escalated to a national level. So there must be collaboration within the current system. But the focus then on the backlogs is critical from our point of view. We also at a national level with our directors of public prosecutions, we have monthly meetings. We've shifted it to bi-monthly because of the financial constraints under which we are. And in all of those meetings, we have a complete understanding of all of the court roles in the country. We also have an understanding of each of our divisions and the extent of backlogs in our divisions. And in that way, we then make strategic decisions of the focus areas that we need to focus on. So as we speak, we are going into a review meeting at the end of this month with our directors of public prosecutions and some of the other key role players to look specifically at the question of the corruption work and the corruption backlogs, the corruption investigations, and what more we should be doing in order to ensure that those cases are fast-tracked. So to come back to the question that Advocate Breitenbach asked, so what happens to the prosecutors, the experienced prosecutors in the MPA? They are all fully occupied. We are bringing on board senior people, senior advocates who have prosecution experience to support the prosecution. And so in many of the bigger cases, it's a combination of assigning a senior advocate from the bar to support the prosecution and to strengthen the prosecution capacity. But the MPA prosecutors are part of that process. We will also use it as a mechanism to help with the transformation of our institution and, in fact, in transferring skills to the less senior colleagues within the prosecution. So it's a combined effort to ensure that holistically the prosecution is doing much better and that we can improve the manner in which we do our work. I wish to then turn to the question of the fact that...
Sorry, Advocate de Kock, I think linked to what Advocate Breitenbach raised, to what an extent are you using retired experienced prosecutors for this case, for these cases?
Chair, we have used some retired prosecutors. There are currently some retired prosecutors on contract within the MPA. So that is a different process from the one in which we take advocates from the bar. Those are appointments made in terms of Section 38 of the National Prosecuting Authority Act, where the minister can then appoint a person outside of the MPA to be a prosecutor. And there are certain financial implications for the prosecution. The other model that we are using is where we use the experienced prosecutors or some of our retired prosecutors to assist us, but they then get the contract. I must say that this is to the advantage of the MPA because these contracts or these prosecutors are paid on a lower rate, much lower rate than what the advocates on the bar. And we commend them for assisting. Some of them are still fully capable of doing the work. And we have a few of them on our payroll in terms of a formal contract. Those contracts are normally for a year, but it can be extended. So that's the model, but we don't have too many of those contracts, but we have a few, some in the IID, and then some in the SSCU, and some in our general prosecution stream to assist the prosecution. Chair, if I can move on then to the question
what is the ratio between the retired prosecutors and the ones that are taken from the bar?
Offhand, I can't. I don't know the ratio. We can let you have that once we get that information from our finance and our HR department. But off the top of my head, I think there's about 60 plus advocates from the bar, and I think there may be about 10 to 15 advocates on contract who have retired, and that we've asked us to assist, Chair. But we can give you that information, the exact information from the HR and finance.
But in an environment of a constrained financial environment, fiscal environment,
yes.
Why are you not focusing more on the ratio of retired prosecutors than going to the bar, which is much more expensive?
Yes, remember at the time that we started this initiative about 2 years ago, funds had been set aside for this purpose specifically, and also to supplement the experience within the prosecution. So that is the reason. Under the current financial constraints, you're correct, it will be more prudent to get prosecutors who have left the NPA on retirement to come back. But of course, there are also challenges with that. Many of the prosecutors who retire are not interested in continuing to work on a contract basis with the prosecution. People have reached the end of many have reached the end of their abilities, or they want to retire, and etc., etc. I know of specific examples where I've engaged with senior advocates in the prosecution specifically, and after some reflection, people have come back to me and said, no, thank you, but they want to go and enjoy the retirement. So we also deal with that, but we take your point that going forward, this is certainly an area in which we should look more carefully to ensure that we can, where we do have the funds available, that we can appoint more people who retire from the organization to assist with these prosecutions.
Before maybe advocate has that one, Chair, on the very same issue. I wanted to find out if maybe as he's busy maybe working on getting those retired, is there any, because if there are those who are saying they are not interested, they are done with the issues of working and all those things. How about maybe if you decide to bring them back on the basis of advices, at some point you group them together and then they look at those issues into details before they can even maybe be brought to the prosecutors that will be working with them. It's just a question if it's there anything that you will look into going forward in that matter. Thank you.
Yes, I also think that is a reasonable proposal. It's also something that we can do, and there are examples of people not working full-time but working more on a part-time basis to assist with some of the work. But just to say, we don't see this as a major area. We need to focus on our people. Some of these cases will take a long time to finalize, so there are risks as well. And our approach is to focus on people who will have the ability to see the case through to the end. And we don't want a risk also that we employ someone on a contract and then after a year or so, they just don't renew their contract. So there are those kinds of risks that we should also be aware of, Chair.
Sorry.
Thank you, Chair.
Honorable Breitenbach.
Thanks, Chair. I'm interested in the reply by asset forfeiture. While I accept that there's a two-pronged approach and it sounds workable, I assume that the use of international firms comes at a great cost. So I was wondering whether the money comes from the NPA's budget or is there some other way of funding it?
Can I take that, Honorable Breitenbach, for the second round?
Sure.
Thank you. Proceed, Honorable Advocate de Kock. Honorable de Kock.
Thank you, Chair. I move then to the question relating to the FATF issues and the grey listing and the focus on the money laundering cases. Just again, and we have reported previously to the committee in relation to this particular issue on the progress. But just to say, the grey listing doesn't just relate to the failure or the inability to prosecute money laundering. The FATF has evaluated South Africa and has said that we do have the ability and the capability to prosecute money laundering, and we do that on a daily basis in our courts. The outstanding item in relation to investigation and prosecution is specifically to serious complex money laundering. And when we speak about serious complex money laundering, they're talking about the professional enablers. They're talking about the professional enablers. We've heard today during the course of this presentation that there are particular initiatives to address enablers, and particularly in the ID environment. So the ID is leading on state capture corruption and on enablers, and the enablers project is located with the ID, but then also with the partnership through our other law enforcement agencies. We also then focus on standalone enablers, and here we focus on through our SAPS detective services, through the DPCI, and through other agencies, our tax authorities. We also look at the question of how to address enablers. The second aspect of serious complex relate to money laundering networks. These are the networks that facilitate the flows, the illicit flow of money in our country. And we have a number of cases and investigations that we've identified that we will be reporting and that we are reporting to the FATF on. So the FATF has noted the progress that South Africa is making on this and has encouraged our authorities to proceed on the path that we're currently pursuing. Just also to add that in terms of the action item around serious complex money laundering, the termination date that the FATF has provided is January 2025. So we will give a series of reports, quarterly reports to them between now and the end of January 2025, in which we will demonstrate progress on investigations of the serious complex money laundering as I've explained. The last part relating to our strategy to address the FATF shortcomings from an investigation and prosecution point of view is the law enforcement coordination. And I think that since the grey listing, we've done a lot of work to ensure that there's effective coordination between all the law enforcement agencies. I don't think, in my experience, of working within the criminal justice system, that we've had better cooperation than what we're having currently across the board. So we've really set it up in such a way that the prosecution leads in terms of coordination, in terms of guidance, what the evidentiary requirements are that we need in these matters, but the investigating agencies lead in terms of the actual investigations. And there's a synergy now between this and a coordination at a national level with all our partners. I must say to the committee that everybody is cooperating excellently in terms of this process to address the grey listing. So we're very confident that we're making great progress in terms of dealing with the question of the money laundering cases. The final decision that we've taken through the priority committee that is chaired by General Lebeya, and where all the other law enforcement heads are sitting, is the creation of an intelligence-driven approach to deal with the money laundering cases, the serious complex cases. We talk about the Troika principle, which is intelligence, investigation, and prosecution, and we talk about the identification of these cases through the information that we get from the FIC, and then we can then follow the money, and then we can then ensure that the investigations take place. Now, this will be across the board, whether we're dealing with corruption, whether we're dealing with organized crime, whether we're dealing with tax-related crimes. So that is the approach, and that is now being set up in the FIC as we speak. We don't talk too much about it. We want this model to be working effectively, but the committee will remember in terms of the General Laws Amendment Bill that the committee assisted in getting through Parliament, the FIC's role in terms of strengthening investigations through our financial investigations. The FIC now has authority and powers to also do certain financial investigation in serious complex money laundering. So we think that all of those factors, all of that coordination and all of that working together is really helping us to address that particular shortcoming that the FATF has identified on the through the grey listing process. If you allow me to move, Chair, I'm just looking at my notes. I think that Honorable Yankee did also speak about the backlogs and what is being done. I hope that I've addressed that. Advocate du Plessis has also spoken about the resourcing issue and the budget issue. So with your permission, if there is anything outstanding, then please remind me on that. I'm looking through the notes, then I'm coming to a question that Honorable Jele has asked us. This related to the balance between the work that must be done in the TRC and the work that must be done on the state capture corruption work. So the approach that we have followed is that we've separated the work. So that's the first point. We've also organized ourselves nationally to ensure that there's a strategic approach in terms of how we do that work. So we spoke about the corruption part. As far as the TRC is concerned, we will report to that in the next phase. But just to say the work is separate, we've also got dedicated capacity in the TRC cases. And here we've utilized the contracts. So currently, I think there's about 16 or 17 permanent contracts within the NPA working together with some of our other prosecutors in our directors of public prosecutions divisions to deal with TRC. But we'll expand on that a little bit later, Chair. So I think that is, I hope that I've answered the rest of the questions, but that is the submissions made on behalf of the NPA. Thank you.
And I now note the following hands, Honorable Janji, followed by Honorable Mkwebane, and then Honorable Breitenbach, in that order. Honorable Janji.
No, thank you, Chair, and I welcome the responses. Have been helpful in many ways. I just wanted to make a follow-up on Advocate du Plessis, Honorable Chair. I think he might need to do more homework, much as I like the sound of what he was raising as a last point, this need to budget for specialized skills. You remember, I would have asked the increased 226 legal staff, what they are made up of. Because only prosecutors and lawyers were mentioned. And so he would have listed as part of what they need the project management, which is a serious lack in government. A lot of our problems are as a result, the pace of doing things, monitoring it, and identifying the risk has a lot to do because project management together with risk management is not mentioned that. I welcome the forensic and so the issue for me then is taking from what he's saying, I don't know if they have worked on a plan, because the last thing you want is for us to interact with him on anecdotes, just ideas flying around or what they think should happen. Because with the NPA, from where I'm sitting, I'm more interested in their capability than the many warm bodies you must have. So in other words, I am interested in not just a bus full, as Jim Collins would call, but I'm more interested as to if this bus is full, are people in the correct seats? And do they have the correct skills and capabilities? Because with the work that it is facing, the issue is not to recruit thousands and thousands. The issue is to focus on whether the NPA has the kind, because what are they dealing with, which would have been seen not even before the State Capture Commission. There's a sophistication of crime that is happening, and with old skills, you left very much far behind. And so what he would have mentioned is very interesting to me, but I'm more interested as to, is there a plan they've worked out that they want to make a case about, persuade, to say, in order for us to be a better NPA that is able to deal with these issues, as he mentioned, this is what we need. At this stage, I would leave the money issue, $500 million or whatever that he was raising, and focus more on that sets of skills. And as part of that plan, before they even want to seek more money from the department or treasury, having gone through their annual report, it might even be important that they start within the department. There are areas that I've seen in the annual report which looks like very nice to have issues. So the reprioritization will have to start there to say, we have identified that this package and set of skills, and we need them, and this is how much we're targeting. And within NPA, so much can be budgeted for that. And then the committee then comes in if there's a need in assisting within government. I also welcome this issue of partnership, especially if those partnership, there are clear parameters, so that their independence and their credibility is not encroached on those issues, including matters of training and so on. And so much as the question that I asked of the further skills has not been answered, I think he has answered it in the manner that he has responded. But I would want that they not to respond now, but to do a bit of homework and package that properly to kind of set the NPA apart from, and just take it to the next level, just based on that level of capability. And I know I would have mentioned this in another committee. I'm part of that. We've seen it in many other countries, including in military terms, Chair, where you can have thousands and a million army, but if that army does not have capabilities, it can be defeated by a very small and fewer army that has got serious capabilities. So the issue is not just numbers. The issue is, are you investing in proper areas that can match what you have to deal with? That's where the NPA has to be, so that it ceases to be just an ordinary. As we deal with the issue of the bill in this afternoon, the issue is not about looking back how we were. The issue is about the kind of NPA we need for the future. And for me, that area of work is critically needed. Thank you, Chair.
Thank you, Honorable Mkhwebane.
Thank you, Chair. Thank you so much for giving me the opportunity. I wanted to follow up when Advocate Mayor Johnson was speaking on the issue of the ABB and acknowledging that there's no legal provision which they've utilized or which in that settlement agreement. I think, Chairperson, this matter is very much serious in the sense that even if it's an agreement with the company, and I think we can still have a session where we can deal and deliberate on this settlement agreement and see how we can prevent such, because it's like if you are well-resourced, you can proceed to do that. And I think, and I'm wondering why, because they were upfront, they wanted to settle the matter, why they didn't use Section 105 capital A. But then coming back to that section, and as well considering the issue of dealing with the backlog, and I think agreeing with Mr. Honorable Danji on the issue of your program project management way of dealing with your backlog, because indeed, firstly, you cannot always want to have more bodies, and you have people who are working. But then the question is, what are their performance agreements are saying? Well, you've got your strategic document. How is it filtered down to each and every individual prosecutor? What are their targets and their performance agreements? What are they saying? The service standards, how many matters they should be finalizing, and to what particular rate. So I think that information should be provided to us so that we can see how we can also assist in dealing with it. Chairperson, I'm mentioning this because, I mean, if you check the district courts, when the minister was responding to a question of the backlog, was saying in the district courts, there's 26,965 backlog cases, and the current court roll in the magistrates district courts is 136,387. Regional court, the current court roll 51,000. The high courts, the current court roll is 756. So I think with the current capacity and what are the service standards saying, and as well thinking out of the box, dealing with the provisions which are there, especially Section 105, capital A. And I think I would say let's start and focusing on those crimes which are, well, not so complex, but would say minor crimes, though it's crime, but then and see how we can fast track and deal with those and move them out of the way. But again, Chairperson, I'm still very much concerned about the issue of even if it's the company itself and not its employees, but then I think we should deal with that separately, because if any other company would come and say, okay, we agree, we will pay so much money, and we don't even, we've done that out of the legal provisions of the country, then we are in serious trouble, because again, we are still contributing to the very same elements of what FATF or what the findings are all about. I mean, the statement which was issued by the NPA was also very much misleading, because they were saying the payment which was made, this agreement was reached in line with Section 664E of POCA. And I mean, if there were no legal provisions and why that agreement was entered into, I think a lot has to be dealt with. And even if people are agreeing and pleading guilty, I think let's follow that process, because they've agreed. They will avail more information, and they will also give us a lot of evidence and the leads for us to deal decisively with corruption. And the worst part, Chairperson, is that the very same company in South Africa is still continuing to operate as if nothing has happened. And I mean, if we are serious about dealing with crime, we should deal with crime, and people must face the repercussions of that. Coming to issue of CARA fund as well, Chairperson, I don't know how far have we gone to check, because I see in the budget review, it's mentioned that some of the money would be utilized for the sexual abuse or courts. But then the issue is, have we checked how much is there? How is it utilized? How can it also assist in making sure that NPA is focusing on their mandate? Going back again to Advocate de Kock, I think it's very much critical that we focus on the issue of the current capacity within NPA. They are monitoring their performance, their targets, instead of continuously using advocates on the bar. Because I mean, if we are then weighing options and creating a balance, as my other colleague has said, we should be making sure that we avoid such. But then again, coming back to the bill, you cannot legislate for inefficiency. Therefore, the current capacity we have, let's relook into it. Let's make sure that we deal with the capacity and handle the backlog and try to engage more on Section 105 if we have to remove those. And again, going back to the issue, why bring the matter before court? Now you are saying it's the court and it's no longer only the NPA. Let's not rush to take matters to court or even arrest when we are not ready to, or with our evidence and our witnesses, and it's a tight-knit case. And when we go to court within 3 months, the matter is dealt with and dusted. Thanks.
Thank you, Honorable Maseko Chale.
No, Chair, I withdraw my hand. I think I was covered. Thank you.
Thank you, NPA.
Thank you, Chair. I will first ask Advocate du Plessis to respond to the question from Honorable Jantjies. Thank you.
Thank you.
No, sorry, I think I made a mistake. Didn't I ask Honorable Breitenbach to delay her question for the second round?
She did raise it. Oh, her hand is up.
No, my
No,
apologies.
Chair, my hand isn't up. I did ask the question. I can repeat it, but I'm not sure they've got it, so I didn't see the need to repeat it. Thank you.
Okay, thank you. NPA, over to you.
Thank you, Chair. I think the points made by Honourable Jantjies are excellent. I know he doesn't want to answer now, but we will certainly be looking into those issues in detail. I just want to remind the committee, we have reported on this in the past, but the NPA about a year ago embarked on an in-depth initiative which involved an independent assessment of our capacity. We called it our Capacity Review Initiative, where we literally went across the country and asked exact questions that Honourable Jantjies was asking about. What is the skill level of our existing staff to deal with complex matters, particularly the state capture type of matters? We're still finalising that report. We plan to present it to the committee as soon as possible, hopefully early in the new year. And that report does exactly what was suggested. It looks at where the gaps are, what kind of skills we need. What I can give the committee some assurance on is that the initial findings of that review, and we really looked at hundreds of staff across the organisation, was that the general level of capacity in the NPA to prosecute serious matters is actually very high at a mature level. The real challenge comes, as Honourable Jantjies said, within the very specialised skills, particularly around digital forensics, digital evidence, some areas of international cooperation, and some of the very specific specialized skills that are needed. And what the review will do is not only identify where the gaps are, but also make proposals around how to fill those gaps, both in terms of building internal capacity, but also the kinds of skills that might be needed to be brought in at the short, medium, and longer term. So, Chair, we can share those preliminary findings with the committee as soon as we have them. And then we hope to brief the committee in detail, hopefully this committee still at some point, when we get that review, which will inform our more scientific approach to the capacity enhancement process. Thank you.
Advocate de Kock.
Thank you very much, Honourable Chair. I think the last questions asked then by Advocate Mkhwebane. So I think we must not lose sight of the fact that the law does make provision for the prosecuting authority to have a prosecution policy. This is a formal document. It was the original policy has been signed off. The National Director signs off on the policy. And so there is a legal framework within which decision-making, all sorts of issues relating to the work of the prosecution happen. So it's not a haphazard approach that we follow. in terms of how we conduct our work within the prosecution. It's in the framework of the prosecution policy. Secondly, it's also subject to checks and balances within the prosecution. At the first level, we have prosecutors who are under the control and direction of directors of public prosecutions, including the investigating director. So the investigating director is a director of public prosecutions, appointed to be an ID within the NPA, and has a number of staff under her. And so the checks and balances would be that at the different levels within the organization, the work of the individual prosecutors are vetted and are checked, and we ensure the integrity of the decision making that happens within those things. So we take those processes very, very seriously. Once it's done at that level, the law also makes provision for, in the event of any person being unhappy or concerned or aggrieved by a decision within the prosecuting authority, that representations can be made to the national director. And so that process is also in place. And I must say to the committee members that those provisions are utilized frequently, in fact, on a daily basis, by various people to test the decision-making that happens within the prosecution. So it's very formalized, it's structured, and it's in terms of the NPA Act and the Constitution, because the Constitution ultimately sets out the framework within which we work. But I also want to say, just on the question of the ADRM, so it happens within a policy framework, it happens subject to the control and direction of directors of public prosecutions and the national director, and of course our deputies who have responsibilities assigned to them by the national director. But if we look at the NPA Act, the provisions that deal with the institution and the conducting of prosecutions, those are important provisions. So within those provisions, there's an element of discretion. A prosecutor, particularly a director of public prosecutions, doesn't need to prosecute each and every case. There's a discretion based on what is transpired in a particular matter and how to utilize those provisions subject to the law and subject to the policy framework within the prosecuting authorities. So it's within that context that the ABB matter and the settlement of the ABB matter happens. It's an individual case, it's an ad hoc case. Any other case of a similar nature will be dealt with on its own facts and on its own merits, subject to the evidence that the prosecution had in that case. And the ID has tried to explain that in that matter, there was cooperation to ensure that the investigation could be completed in a particular way. So I think we must just bear that in mind. The ID has also indicated to me that we cannot speak too much about the detail of that particular case because it is still the subject of a current investigation. And so we ask for the indulgence of the committee on this, that we don't delve into the merits of that particular matter because it is still part of a bigger case strategy within the ID. And then on the utilization of Section 105As, we have spoken about that as well, but that is again where the defense is prepared to utilize a Section 105A. So that's all the tools that we have in our disposal in terms of how we deal with matters. But each matter, and I think this is where the emphasis must be, each matter is evaluated on its own merits and based on the evidence that's contained in that particular case docket or casework, and what the objectives of the prosecution will be ultimately, and whether or not we can approve a case in court. So those are the requirements that we'll take into account in relation to each case. So, Chair, I hope that I have covered all the questions. I think there was an issue on the... Yes. Yes.
What would you say to a person who says that there seems to be a perception that some companies are too big to be prosecuted? There were companies that were involved in price fixing during the building or construction of stadiums, and we are not aware of any prosecution that happened. that although you might prosecute the employees and the directors, but the company itself, a perception is that they are too big to be prosecuted. What do you say to that?
Now, we say to that that is not the approach that we follow. No company in South Africa is too big to be prosecuted. We will prosecute any company where we have the evidence to support a prosecution of the company. And on a daily basis, we do have various companies prosecuted. So if we go and look at our court rolls, you will find companies being prosecuted. So, but again, I come back to the evaluation of each and every case and a decision that has to be made in relation to that case based on the evidence contained in that particular docket. Chair. Thank you.
Chairperson.
Advocate Kwebane.
I don't want to belabor on this matter for a long time. Chairperson, our role is to make sure that there is justice, there's fairness, and also as lawmakers, we need to make sure that we don't allow that perception to perpetuate. Currently, with the presentation they were making about the progress on on the corruption cases, I wouldn't want to say state capture because that is corruption, and corruption is a crime where there's a corruptor and a corruptee. And those companies with the resources, I mean, you mentioned all of them. I'll give example of the ones they've submitted in their progress report. Let's say you have Trillian, you have McKinsey, you have Bain, you have Tegeta, and all those companies. If they come to NPA and say, we are prepared to avail the following information, we are prepared to pay back this money, don't prosecute us. The fact of the matter is, you say it's a policy within NPA. That policy should be compliant to a legal prescript. Hence, I'm saying that I think this is not a proper way to follow the issue. But Chairperson, I would want to discuss with you on this matter and how we can deal with. But again, I think rather focus on dealing with such matters. If the company like this came forward, they brought all the evidence, they are prepared to pay back the money. Our legal framework in South Africa is that you need to plead guilty, and we agree that this is the sentence you'll be getting, and the court is involved in that particular matter. We are not like in other jurisdictions where they can do it because their laws allow them to do. So we cannot just come and say we relied on the policy within NPA. So that's my concern, Chairperson, because we will then be perpetuating the same thing that some companies, because they are well-resourced, they can do as they please in our country. Then they, after doing that, they pay money and enter into an agreement with NPA, and then they pay money, it's taken to Kara Fund, and that's it. They just proceed with the contracts they have in the country. Because as a country, we should be dealing with the corruptor and the corruptee and apply the same measure of discipline as we would towards those who are recipients of the corruption money. So I think that's the principle we should be dealing with, and we should be standing with, because I don't think it's proper for us just to give it a brush like that. Yes, acknowledging it's very critical, but the statement was issued. They mentioned the wrong provision even in that particular statement, the NPA. They are accounting to Parliament. They should be very much transparent to Parliament, and even how they comply to the laws of the country.
Chairperson, I was going to answer on the Kara aspect.
Before he comes in.
Sorry, Advocate Cook, Honorable Masego Chele.
Yes, it's just small thing, Chair. It's in addition to what my colleagues have just mentioned on this one. there is a dissatisfaction, Chair, when it comes to the payments that is made by these companies vis-a-vis what they have cost the country. I think the NPA must also look into that one. Thank you, Chair.
Thank you.
Yeah.
Dr. Cook.
Thank you, Chair. We welcome all the comments, and I think that our approach is in line with all the comments that have been made. And just to mention that the ABB is just but one case out of the many that have been dealt with by the prosecution. On the question of the provisions and payment into CARA, that only related to the mechanism for the monies to be paid into CARA. So we never asserted, my understanding is there was no assertion that that was the basis upon which the settlement was reached, but that was the mechanism that was used for the money then to be paid into the CARA in terms of the POCA provisions. But Chair, I think that we agree with the sentiments expressed. I reaffirm that even companies will be prosecuted where appropriate, where the evidence is of such a nature that we need to have a different approach in terms of a company or an individual. That is where I've indicated that there's a discretion. And that discretion happens on a daily basis throughout the country in all our courts. The issue of fairness is a critical aspect to the work of the prosecution, and we want to ensure that there's fairness in all the processes that we have. And so, like I've indicated, where there's any issue that anyone feels aggrieved by a decision or by what we have done as the prosecuting authority, there are mechanisms, and we invite members of the public or any other member or any other person to make representations to us in relation to those matters, and we will certainly look into it and respond in writing to all complaints of that nature. And then ultimately, we also know that the courts are also there as checks and balances in relation to the work of the prosecution. So there have been examples where decisions of the prosecution has been taken to court on review. So I will leave it there, Chair, if you are satisfied that we've answered all the questions. Thank you.
Thank you. I think that as part of our handover report, we will also be making recommendations to what the new committee should be focusing on, especially with regard to issues of state capture and corruption. So we will look at mechanisms of how do we take this report forward, the report that we have been given today, as part of the 7th Parliament's work, priority work that should be looked at. Thank you very much, NPA. Members, can I be advised, do we continue with the TRC report now, bearing in mind that we must break for lunch and there's going to also to be a sitting starting at 2, or should we push until 2 and then we take a break at 2 to allow also some of the members in this committee who would be making statements in the House, maybe we come back at 3 so that we can proceed with the NPA bill. Can I be advised? Honorable Breitenbach.
Thank you, Chair. Yes, that second option would be preferable for me, but that's because I have to make a statement, but I'll probably be done quite quickly. So I would prefer that option if it's possible and convenient for everybody. Thank you.
Thank you. Honorable Maseko Chele.
I just wanted to find out, last week, Chair, I requested that the NPA must also come and give us or talk to that document that I was talking about, the issues of vetting. I know for now, I'm not sure how is that matter going to be handled. Are we postponing it after the presentation, or maybe it's still going to be any other day where we are going to talk about that? Thank you, Chair.
I thought that they were going to make the presentation when we deal with the bill, the NPA bill, because it arose as part of the processing of the bill.
Okay, all right, Chair. Okay, I'm happy.
We're fine. So do we agree that we push until 2?
Yes, 10 to 2, Chairperson, and then we can come back at 3. I propose. I think that's a middle ground, I think.
Okay, no, that's fine. Advocate Nongoko, your hand was up. Advocate Nongoko.
Thank you, Chair. I think Advocate de Kock forgot to hand over to me because there was one question from Advocate Breitenbach, where she wanted to know how the international service providers are being funded. I'm not sure if I should, it's a very short answer, Chair, if I should deal with it, or is Advocate Breitenbach fine?
Yes, proceed.
It's a short answer, Chair, to say that the starting point and the basis for the procurement of the services is through a contingency fee basis. And what that means in layperson language, Chair, is that no recovery, no fee. And that is the starting point. And also just to add that in AFU's asset recovery strategy, we deal at length with the benefits and risks and how we manage all of that around the international service providers, because we have a sense that the work of international asset recovery needs to happen with speed. Otherwise, there'll be dissipation, et cetera, et cetera, et cetera. So the short answer, Chair, is that we have a contingency fee provision linked with the international service provider. That is our starting point, where there is no recovery, no fee will be paid. Thank you, Chair.
Thank you very much, Advocate Nongoko. I think that should be a standard approach to everybody who presents before us. People must know that they are not answering only members of parliament, but they are answering members of the public. So I like your approach, Advocate Nongoko. Wherever there is a particular principle, you need to explain it in a layman's term. I think that is the approach we should take, because there are many people who are interested in these proceedings and they might not be lawyers. Thank you very much for that. Can we now proceed to the TRC report?
Thank you very much, Chairperson. I also ask our colleagues to flight the presentation that's been submitted to the Portfolio Committee and to the members. I think that I will try to summarize as best I can the report or the presentation. There is a lot of detail towards the end of the presentation. I will do my best in the interest of time to summarize the presentation. So, Honourable Chairperson and members of the committee, thank you very much once again for the opportunity for the MPA to report on the work of the TRC cases and the investigations and prosecutions relevant to those matters. I must say at the outset that this work is done in collaboration with the South African Police Services, particularly through the Directorate of Priority Crimes Investigation. And that to the extent that there are investigations outstanding, in terms of our legislative framework, the responsibility in relation to the investigations is vested in the police agencies that are responsible for investigation and prosecution. The plan that we have put in place is to ensure that there's close working relationships between the prosecution and the investigation. And we also follow then a prosecutor-guided model of investigations as far as the TRC work is concerned. The first page of the slide will set out the contents. I'm not going to go through all of them, but the members of the committee can see the contents of the presentation. If we can move. Slide 3, as far as the introduction and background that we've reported to the committee before. A separate portfolio was created on the 6th of September 2021 to deal with the TRC investigations and prosecutions. Prior to this, the matters were placed within the Priority Crime Litigation Unit, or the PCLU of the NPA, and the work was done at a national level. Post September 2021, we have involved our directors of public prosecutions, and our prosecution capacity to do this work is then placed within each of our DPP offices. Just to say that this is at the provincial level, and so at the seat of each high court in our country where our DPPs are located, the prosecutors are then assigned this work under the supervision and control of the directors of public prosecutions and their management teams. So just to say that this is a coordinated approach by our national office and the divisions. In our national office, there's a special director assigned to TRC work with a national TRC coordinator, and there's an administrative capacity to assist with the work. We can move. Again, since 21, there's been a more hands-on approach in terms of this work. And it was important for us to do an assessment on each of the matters, to do an audit, to understand exactly where each of the cases were. Initially, there were only 59 cases that were being investigated at the time. But since then, the number has increased significantly, and we'll deal with that later in the presentation. We can move to the next slide. So this is just a methodology that's been set out in terms of our approach to dealing with the matters in our DPP offices. As indicated, there's a critical assessment of the progress or the lack of progress in the TRC and related matters. So this was the first phase in the early stages of 2021 after September, when that was done. We then followed a two-pronged approach to target purposeful PGI, working with the prosecutors and the investigators. And each of our divisions were expected to provide the number of matters that they were dealing with, develop a plan in respect of each matter, and also to advise of progress. There were self-imposed timeframes that had to be completed to follow these matters on a project management basis, to provide returns to the national office on a monthly basis. And overall, we wished at that time to strengthen the capacity of the NPA to do the work in relation to TRC matters. So we involved, and we were always involved with the DPCI. They were carrying many of these dockets at the time. So engagement with the DPCI and the senior management about the approach. An agreement was reached with the DPCI on how we would best focus on the TRC to render quality investigations. And then, of course, the prosecution and the investigators working closely together in terms of that. Also monthly monitoring in terms of through the investigative agency. They have their own management structures within which they have to also monitor investigations, and that we then would compare progress at a national level. We also formalized the approach to the reopening of investigations into TRC matters, new referrals of TRC matters, and the appointment of investigators and prosecutors in respect of those particular matters that are then referred. So we formalized the formal referral process, and that is when the 59 matters grew to 130 plus matters that we are dealing with currently. This is just a slide to indicate the NPA DPCI approach. There's also a national TRC coordinator in the DPCI. We identified the areas that needed to be focused on in terms of our capacity building, training and upskilling of investigators and prosecutors. We did a SWOT analysis in terms of all the issues impacting on our ability to do this casework. We were dealing with cold cases, no dockets, no inquest records, issues around declassification of records, access to National Archives records, assistance that we had to get from universities, and of course, a sharing of information, etc. We also looked at best practices as we went along in terms of this work and the sharing of best practices between all of the agencies that are involved. Also, the TRC work has become part and parcel of the formal operational work of the police and the prosecution, and it's included in the performance contracts of the prosecutors who are assigned and the investigators who are assigned. So this is just a mechanism in government that we ensure that the work is properly located and the work is getting the necessary attention. One of the features we introduced is what we call accountability sessions. This is where the MPA and the prosecution and the DPCI would meet on a, can we just go back to the previous slide, please? Would meet on a regular basis to evaluate the progress that are being made in those investigations that in every specific TRC matter. These sessions are normally held over 2 to 3 days and informed by the volume of matters in each division. And that we then have a session where we will include the heads of these portfolios from our national office with the local investigators and the local prosecutors and management teams. So it's a formalized process. If we can move to the next slide, please. And just to give the committee an understanding of how we approach this work, the first day of the session comprises discussions and updating on the latest legal developments. Sometimes there's judgments that are given in our courts on certain matters. And of course, we interrogate those court cases and we learn lessons from them. We look at best practices in other divisions and how to deal with certain challenges and how to overcome certain challenges. What we need to emphasize is the uniqueness of this work and always the lack of direct evidence that is available to the prosecution in relation to the deaths that have occurred in relation to the victims in these matters. So we have to look at other ways to collect evidence, other ways to present evidence, to use experts to present to the courts so that we can get findings in the favor of the state in these matters. So we normally set it out over 3 days. We look at all the cases. We encourage prosecutors and investigators to share their experiences and to engage constructively in relation to the work that they are doing. Any challenges that we cannot resolve are normally then referred to the Director of Public Prosecutor or to the National Office to assist to unlock any of those challenges. This slide will just indicate some of the accountability sessions that have been held in the different provinces. So the committee can see the work that has happened in those provinces. If we can move to the next slide. And then these are, in fact, as we speak, in the Western Cape, we're having an accountability session. And then we also will follow up in the Free State and in the Northern Cape. Hopefully that will be completed by the end of this year. Flowing from previous committee interventions, there was a concern that the family members of the victims were not fully updated on a regular basis. What we have done since then is really to strengthen the engagement with families. We also issue directives from the National Director to our prosecutors to constantly report to family members. And I must say to the committee that a lot of progress has been made in that regard, and that we always would share information on the progress of the investigations with family members. There are also formal structures that have been set up. The Apartheid Victims Family Group is one of those structures. We've had formal meetings with this group. They've also had meetings in all of the various divisions where cases were discussed. And so we're really reaching out in a collaborative way with the family and with any other institution that can assist us to get these investigations finalized as speedily as possible. So regular engagements and updating of families ensures that when decisions are finally taken on their matters, be it a prosecution, an inquest, or to close the matter because all leads have been exhausted, family members are aware that the investigator and prosecutor have explored every possible avenue before arriving at the decision. If we can go to the next slide, please. This is just a reflection of some of the work that we've done in relation to the family groups, the institutions and the formal meetings. And we can see that we've covered quite a wide spectrum of our provinces. Some provinces are joined, particularly in Gauteng when we meet in Pretoria. And as you can see, the last meeting we held was on the 28th of September. This was at the National Office of the Prosecuting Authority. I'm on page 14 of the Prosecuting Authority, and we have various representatives of the Apartheid Victims Family Group present. It was a very productive meeting. There were still issues brought to the table of concern. Those issues have been taken seriously, and the feedback will be given to those members and to this particular body on an ongoing basis. The next slide speaks to the dedicated capacity that we do have. I must say, and I must alert the committee to the fact that, as I've indicated previously, this is the area where we have contracts. We had more contracts than what we have at the moment. The problem with contracts is that the person on contract can leave you at any stage if they get a full-time employment. And so that is something that we are concerned about. We have motivated for permanent capacity within the prosecution to be able to deal with these matters. But we also rely on our existing permanent prosecutors to support the work of our contract prosecutors. So it's not as if we only rely on the work of the contract prosecutors. But we note that it is an area where we have motivated for additional capacity, permanent capacity, to finalize the work in relation to the TRC casework. And that is the next slide. The next slide will give an indication of the dedicated capacity between the DPCI and the MPA, between investigators and the prosecutors. If we can move. These are the matters under investigation. 129 as at October 2021, 55 matters were then formally under investigation. It had to be reopened, and currently we then are dealing with 137 investigators. The matters that we have finalized with the decision are 18. As we are aware, some of these decisions are to prosecute, and some of them are to refer for an inquest, and some, or the least number is where there's a decision not to proceed with the matter at all because of a lack of evidence. The bulk of the matters are thus far, we've managed to ensure that they speedily got into the inquest court, and the advantage is that we are managing to bring closure to the families, and many families are requesting that a formal inquest be held where the evidence can be presented to the court and where the court can make findings. We have had very good judgments in this regard, and the most recent was, in fact, the Imam Maroon judgment right here in the Western Cape, in Cape Town. There's currently 13 matters on the court roll. So as far as the matters that we are dealing with and the spread between the divisions, Honourable Chair and members of the committee, these are the matters as set out on the slide. The Western Cape 11, the Free State 3, DPP Makanda 10, Eastern Cape 12, so the broader Eastern Cape 12, the Northwest 9, KZN 28, Mpumalanga 7, Northern Cape 7, GLD, Gauteng Local Division 22, Gauteng Division in Pretoria 15, Limpopo 13, which gives us the 137. Again, just we have reported on the various stages, but in terms of how we categorize between A, B, and C, 0 to 33% of where the investigation is, 35 to 65%, and then 66 to 100% is category C, where we are nearing the completion of the investigation, where a prosecutor is able to make a decision based on the evidence that's been collected. We can move to slide 20, Chair. Slide 20 will then give an indication of the progress as I've set out in terms of the key on the first page. And this is where our matters are currently. You can see that many of the matters are in the brown or the gray, which is the C category. So these are the matters that we will then be enrolling in our courts shortly to ensure that these cases are dealt with on the court roll. Again, the pie chart indicates the progress to date, and it shows which matters are under investigation and which matters have been finalized, and then the pending matters in that slide. We show the October progress. That is as at October. That is the progress that we have in terms of the matters under investigation, matters finalized, and the matters pending in court. As far as the challenges are concerned, Chairperson and members, the first is, and I have spoken about this, is that prosecutors are employed on a contract basis. It's a deviation that's been authorized through National Treasury and the DPSA for the creation of these posts. We do have an exodus of these prosecutors to other full-time employment, and we've thus lost 10 of our dedicated prosecutors. But like I've indicated, the work does not stop. We rely on our current prosecutors to continue and our dedicated prosecutors within the DPP offices. So we commend our DPPs for doing everything within their power to ensure that these cases are getting the necessary attention. When we appoint a new prosecutor, of course, there is a rebuilding of a relationship with the families, but because of the accountability sessions that we put in place and because of the formal way in which we meet with families, this is helping us to ensure that family members are kept on board, and how we explain to family members if there's a change. But those changes are inevitable when people leave us for permanent employment. Previously, we spoke about the impact of the lack of proper dockets and inquest records. We speak about the access to TRC records that are maybe in other state institutions. The witnesses, accused suspects, persons of interest are deceased or old. And in some instances, witnesses have been unwilling or afraid to cooperate with the investigating authorities, the investigating officers, and the MPA. We do our best to allay the fears of witnesses, but just to note that this is a very sensitive area of our work, and we do everything in our power to protect our witnesses. And that is why, Chair, we also don't publicize these investigations too much, because there are still risks involved in terms of managing the investigation and managing the witnesses or the potential witnesses that we have. So we try to, as far as the actual investigation is concerned, share the information with family members and with the lawyers in certain instances that's been appointed on behalf of family members, just to keep the integrity of that investigation intact. We spoke about the government departments, where we do sometimes get a slow response. We've raised challenges with the vehicles for investigators, with the DPCI management and the police management. That sometimes impacts, particularly in our rural areas where special purpose vehicles are needed to go into difficult areas, inaccessible areas. We are obtaining a list of experts. We're building a database of reputable service providers that can provide expert evidence in these cases. And we have seen good examples of how to utilize expert witnesses in these cases, where we are able then to reconstruct the scene. In a way, you are bringing fresh evidence by taking historical data, looking at what happened, what do we have available, reconstructing scenes, and then we get an expert to give evidence on that. Or on postmortems as well. We may not have the original postmortem doctor available. We use the records, we get it examined by another experienced pathologist, and we utilize that pathologist then to draw conclusions from that evidence, to present that evidence to the court. So that is the strategies we have been following in trying to get these cases done as speedily as possible. We have mentioned the accessing of details of witnesses. We don't likely share the details of our witnesses for the reasons I've explained, and we are also not too keen to publish the list of names of cases that we are busy with, Chair. To the extent that the committee may want that information, we will readily make that available to the committee or to the chair on a confidential basis. But like I've indicated, that these matters are still quite sensitive. And as we are digging deeper, the chances and the risks will increase in terms of those cases. We do have a first conviction post 2021 on the 8th of November. The state versus Wesley Matiri Modansela is guilty of murder and got a sentence of 10 years imprisonment. If we look at some of the other matters currently on the roll, State versus Marais and two others, this is enrolled on the criminal court roll. State versus Rodrich and another, that's the COSAS 4 matter. It's enrolled on the criminal court roll in Johannesburg. State versus Kotsia and another enrolled in the criminal court roll in Pretoria. These are all high court rolls. The Wesley Modansela, this indictment and prepared. This is the second matter relating to the previous accused that we have convicted. So there seems to be another matter that we are busy with. Then, as far as the inquest judgments that we have received, Honourable Chair and members of the committee, we have a judgment in the Dr. Neil Agate case, and Chair, the importance of the inquest, where there's no prosecution, is that we do bring closure to the members of the families. I think that's the first point. The second point is, or potential for closure, and we know that it's very difficult to have absolute closure, and that the consequences of these actions will continue indefinitely. But the second part of the value of an inquest is that we are able to harness information about what happened, how it happened, what tactics, what methodology was employed, etc. So in a way, we're writing the history as well through our courts in terms of what has happened. And from my personal view, I think this will stand us in good stead as we write the history of our country, that we utilize the mechanism of an inquest court and the liability that the inquest court and the findings that the inquest court makes will be so important for the future and for future understanding of what happened during this era in our country. We also have the Ernest Dipali inquest matter, where we had an inquest judgment. We had the Haffajee matter in KZN, where also the suicide finding was overturned with the finding of murder, and then also the Imam Haroon matter, where the Western Cape High Court also made a finding that the death was brought about as a result of torture by the security police at the time. Currently, cases on our court rolls, Ms. Nkubeka, SBO Piwa, Zama Sokulu, James Mngumezulu, and Mr. Mutunzi Flemeseni. Those matters are currently on our court roll. So we are doing everything in our power, Chairperson, to expedite the enrollment of the cases on our court roll. And we must say that because the cases are going through some of the cases are going through the inquest court, other cases are on the criminal court roll. In the inquest court, we are finding a much faster process to get the matters heard by the inquest court. And all of these matters will be formal inquests. So these inquests won't happen behind closed doors. It will be open to members of the public to attend. It also requires that the evidence of witnesses will be formally led. It also means that the family members are represented by the state, the prosecution, but they also have the right to appoint their own legal representatives once the matter is in the inquest court. And so that all provides a different type of accountability that we can utilize in the inquest environment. And we find that the inquest courts are processing the work speedily on our behalf. So we are grateful for that, Chairperson. If we can move to the next slide. The MPA has requested Advocate Dumisa Nsibeza to provide an overview of the work, an independent assessment of the work of the MPA and the measures the MPA has put in place to deal with the TRC matters and the issue of delays that were caused in these matters. Advocate Nsibeza has provided his final report to the National Director. That report is currently, the recommendations and the evaluation of that report is currently under consideration, Chair. So it has been forwarded to the National Director for consideration and for an appropriate way to deal with the report going forward. So I just bring this to the attention of the committee that the NPA has received that report. Chairperson, that is the presentation, and thank you very much for the opportunity. We welcome any further questions for clarification. Thank you.
Thank you, Advocate de Kock. I still want to emphasize that these reports, you are reporting to the nation via the committee. It's not for the sole preserve of the members of parliament. And I think this report to a member of the family who is watching, or member of the public who is watching, is very thin on details. And it's not, I mean, the previous reports were far much more better. In fact, sometimes I think it is very painful because you are reducing a very painful period in our lives to just numbers. I really do not, I was at pains not to stop you. This is certainly not a good report. You might have made a lot of progress, but the manner in which you have prepared the report is not good. It's not good at all. And this is not only a report for the families concerned. These people were not just family members, but they were leaders of their society. They were leaders where they came from. They were leaders of the broader society. So it's not only us and members of the family who has interest in the developments. People who would want to know, people of Ekurhuleni who would want to know what happened to Kefas Nyoka. The last report gave some details. This one, there's nothing. To Mrs. Melanie, the last report was much better. This one is just giving us nothing. And it's not good that you might have provided information to the committee, to committee members. It's always important that when we have to come now and have to come before the committee, we must not just take it as members do have the information, members of the committee doesn't matter. So committee members will decide how do you want us to proceed with this. But on my side, generally, I am very unhappy. I generally think that we might follow, but generally, members of the public broadly, they can't follow this report.
Chair, I take the guidance that you have provided. It's sometimes very difficult to report on progress when it's linked to previous reports. So with your guidance, we certainly, and I hear you saying, let's give more detail of each and every matter. We're happy to do that. But of course, taking into account the sensitivity of a particular investigation. But we can easily rework the report by giving to the committee more information on each and every matter. And if that is the request, Chair, then we can certainly do that quickly to get that to the committee. Within a few days, we can do that for you.
Thank you. Advocate Breitenbach, Honorable Maseko Jele, in that order.
Thanks, Chair, and I align myself with your comments.
Okay.
Hello?
No, I was saying apology. I've raised my hand. It's too dark,
Yes.
Chairperson.
Yeah, no, my apologies. I've just recognized your hand now. You will follow. After Honorable Maseko Jele, if that's in order. Thank you. Honorable Bredenbach.
Thank you, Chair. I align myself with your comments. I understand that the matters are sensitive and that the NPA has many other matters, and I worry sometimes that they spend so much time reporting or preparing reports that is one of the reasons why they don't, that impacts on their ability to do other work. But these matters are important, Chair. You're quite right. They reflect a very significant period in our past. And the people involved in these matters deserve to be treated with great care and with great dignity. And so I wonder if we shouldn't, for a better report on the TRC matters, arrange an in-person meeting, Chair, in Parliament for these matters. It's, I think that the members of the families can also attend. I think it's I think this matter deserves more attention than it's getting. Thank you, Chair.
Thank you, Honorable Breitenbach. Honorable Maseko Chale.
Thank you very much, Chair. I think, Chair, you have covered me so much that you would remember when I started coming in, how I felt when the report of the state capture was presented in compared to this report. This is how I felt, Chair, and I feel, in actual fact, even if Advocate de Kock can also say maybe the previous reports were better than this one, we still don't want the numbers, Chair, and we still don't want. We want to hear, much as there is a feeling of saying they want the society want to see the perpetrators of the state capture in orange overalls. It is worse, Chair, with this one, the TRC cases. Some of them are dying. I indicated earlier, I wanted to make an example on the balance between the two matters, Chair. My apologies for that. My issue, Chair, I'm looking even at the challenges that they have, Chair. Their challenges, Chair, it is they are just listing them. They don't even indicate as to how are they going to deal with those challenges. If you check, Chair, for example, I don't want to talk about the issue of capacity, because it has already been mentioned even in the state capture. The issue of the lack of dockets and the access to TRC records, Chair, those challenges that they are mentioning here, the dockets that they are talking about, Chair, they are saying some of them are even been destroyed before 1994. We are not even being told as to what is going to, how are we going to assist in making sure that everybody who brought their cases forward, they are going to get justice out of this. People went to TRC, Chair. Some of them, their dockets are not found. These people are sitting there. We are talking about these ones that today we are able to point and say maybe their cases can see the light of the day in court. But what about those whom some of them can't even their matters be taken to court because of lack of those documents? I think this matter, Chair, has to be taken seriously, like any other matter, as the department, I meant to say the institution is doing. So, Chair, my other issue is the issue of the witnesses. Yes, the families, some of the families, like I said earlier, they are now suing the government. They want to sue the government because of the delays that are taking place within the institution, the NPA. For example, Chair, they are saying some of their challenges is the weaknesses, accused, suspects, persons of interest are deceased or old, witnesses unwilling or afraid to cooperate with the investigation, Chair. officers, investigating officers. My matter is that are they going to come here and lament that people don't want to come forward? People are not willing. Even the accused, they don't say, in this case, we have these accused and we have these suspects, and they don't want to come forward. It seems as if this matter has been is just taken very light, Chair. I think I agree with you. I think they must come back, Chair, and come and give us the details of all these issues. The government departments in possession of documents. Are we here to beg people, Chair? Are we here to beg departments to respond to the wrongdoings that happened to people, to the country? Is it because this thing happened to the Black person? I'm sorry that I'm going to put it like this, Chair. Is it because of it happened to certain race? That does not matter. That this matter of TRC is being taken this way. Chair, we are, I'm sure how you are, how you are feeling right now. This is how the community is feeling. And this is how some of us are feeling. We feel that this matter must be taken as serious as the other matters. There are people, I have just mentioned the issue of the what do you call them? Those who were the enablers, Chair. There are people who should have been part of this thing, who are still alive, who are still in the departments, who are making. That is why, Chair, today we have people who don't want even to be vetted, but dealing with these cases. I agree with you, Chair. This matter, we have to take it serious. They will have to come back and give us more on these reports, more than the numbers that they are giving us today. I pause, Chair.
Thank you, Honorable Mkhwebane.
Thank you, Chairperson. Honorable Jele has said a mouthful, because sitting here, being a member of the public, as you are saying, Chair, and correctly saying that they are talking to the public, for me is in the so-called corruption of after the inquiry by Chief Justice, the so-called perpetrators might be regarded as Black. And the so-called perpetrators in these matters are mostly those apartheid police and all those. Now, for me as well, the issue is, it's like a Black life, it doesn't matter. Because the speed and the commitment, I mean, how many years now these issues are being dealt with? And I agree with you, Chairperson, and what Honorable Masego Jele is saying, and Honorable Breitenbach, that actually let's have a very comprehensive report. And it's also good that if we can even have the families to be present so that they can see that we are here as the parliament of the people being concerned. But again, I think that passion from the colleagues here, or presentation by Mr. de Kock, it should be very passionate, like how you were presenting the previous report and the commitment you had in dealing with these matters, because it gives that perception that these matters do not matter. I mean, there are attorneys who've passed on. How far is it from the department to make sure that there's replacements? And it's even worse because the state has even availed legal representation in these particular cases where people just butchered family members, and the children were raised without fathers, mothers, and all those. I mean, Simelani's family till this day, they would want to have closure. So I don't know as well, Chairperson, because true, you are saying, Advocate de Kock, that, inquest, sometimes it also makes that process to be, because you can hear what actually really happened for you to kind of find closure. So the question is, why can't we then identify as much as possible matters which we can put through that process of inquest? And even if those accused persons have passed on, but I think we still need that process. I mean, I've seen in the other corruption matters where even one of the deceased so-called suspect, now you are even talking about attaching or dealing with the deceased estate. Now these ones, they are passing on and nothing is being said about those. So I think we need a report. We need to deal with this matter with the same passion we dealt with the other matters. And indeed, this is long overdue. It's unacceptable. Agreed, Chairperson. Thanks.
Thank you very much, Advocate de Kock.
Thank you, Chair. I'm very concerned that the difference in terms of how we present is regarded as a lack of commitment. I want to say to this committee.
Sorry, Advocate de Kock. Chairperson, sorry. I just wanted to say possibly even the Advocate Nzebesa's report, if we can also be provided with that when they come back with the comprehensive report. Sorry, Advocate.
Supported. I wanted also to raise it.
Honorable Jelle, you speak to the chair.
My apologies, Chair, my apologies.
Thank you, Advocate de Kock.
So, Chair, we take the comments about the presentation, but I was saying that I am concerned that because of concerns about the nature of the presentation, that speaks, the conclusion drawn is a lack of commitment. I think this MPA leadership and the measures we put in place to 21 and previously reporting on the progress, we've demonstrated that the commitment of the prosecution to deal with these matters. I want to also say, Chair, that this is an absolute priority for me at the personal level and for the MPA through all our regions. And any notion that because of the race of the victims in this matter should really be debunked immediately. We are committed to dealing with the TRC cases. We are committed to being accountable for the work, and the emphasis in terms of what we can present to the members of the committee. That point is taken, and that's why I said up front that we will come back and give more information to the committee. So just some protection from the chair on this, please, because I just think that some of the comments that's been directed at us is not fair. We demonstrated in 3 or 4 reports to the committee the progress that we've made. When we started, there was nothing. There was nothing. And we have moved quite significantly in progress on these matters. So we want to say to you, and we take the point to the members of the public, that the MPA is committed to dealing with this work, and we will then report on each of the investigations. Maybe the mistake we made before this presentation started was that you did raise the question of time. I almost got the impression that time was a factor, Chair. So to the extent that I didn't come across as committed to the previous presentation, please just take into account the comments that and the discussion that was made regarding the question of time. Then I accept responsibility for that. But that should not translate to a lack of passion and a lack of commitment to do this work. We are very, very committed. We discuss these cases on a daily basis with all our regions and with the police investigators. So, Chair, if we can just get some protection on that, but we take the point and we'll come back with a more detailed presentation on each of the matters, subject to the understanding that those cases are also under investigation. As far as the Ntsebeza report is concerned, that we will direct to the NDPP, and I think the NDPP can liaise with the chair. I'm not sure of the status of that report. It is under consideration by the national director, and I think it must also be referred to the minister. So just bear that in mind in terms of the status of that particular report, Chair. But I'll ask the NDPP to engage with the chair on that report. I'm not sure if there's any other aspect at this stage. I do understand the committee saying that we need to come back, that we need to enhance the report, which we will do, and that we will then take further detailed questions on each of the matters, which we're happy to do. Thank you, Chair.
Yeah, thank you very much, Advocate de Kock. Many years ago, I thought that I wrote one of my best assignments. I had done a lot of research, but when I was supposed to load it, I loaded the question and not the assignment. And as a result, I got 0. Because I did not load the actual work that I did. I just loaded the question. So I do think that you have done a lot of work, but you are not reporting on it. At some point, I was reading through the report, the work we have done with the Mamelodi 10, the Mamelodi 4. There is a lot of progress. But what I think is making the tempers to flare is because it's not reported. I do think that what we are asking, that report, those reports must come to the fore, so that members, we are able to take through members of society that this is where the matter started, this is where it is, these are the challenges, this is how we want to deal with the challenges. Because I think in preparation for that meeting, there are other issues that as a committee we need to deal with. For instance, I think is with regard to the Simelane case, where the state attorney's office is refusing to give, I think, the other person lawyers, and as a result is delaying the case. And then there is also another, I think in one of the cases where despite decisions of the courts, the SAPS is refusing to give other people legal representation, and the cases are getting postponed. So these are some of the challenges that are making, in fact, are impacting into long delays into some of these processes. Now, I think as a committee, we might want to, as part of the process, to have that particular state attorney appearing before us. Why is he delaying the process? Maybe the National Commissioner of Police, because we must identify also stakeholders that are within our oversight powers who are not contributing meaningfully to this process. And they must also be held accountable. I do think that as a committee we would need to meet to say who do you want to bring to the meeting, to that physical meeting, and you prepare the detailed report. We are able to identify what extra role do we need to play to ensure that some of these things are unlocked. One of the painful moments, it was last year, the last time I met with Comrade Musi, who was part of the COSAS 4, who was bitterly complaining and even crying. The following week he died. That's how painful this process is. It's an emotionally touching process. I think even members here, they are mostly reflecting the pains of the people they represent. It's not we are, especially those of us who stay in townships, it's very difficult. But on a daily basis, you are confronted with these questions. Where I'm deployed in Davidton, and that is where Caiphas Nyoka comes from. And every time I must answer to the people of Davidton, what is happening to the case of Caiphas Nyoka, and many other cases. They are very, it's an emotional, very emotive kind of a situation. So we will discuss with other members of the committee, and then we will revert back to you. Thank you very much, members. Honorable Maseko Chele.
Thank
Chair,
you,
could I
Chair.
ask a question?
Sorry?
Could I ask a question, Chair? What is
Okay.
your direction regarding the report? Is there any direction at this stage, or will you come back to us on the report, on the further report? Is there a time, must we by a certain date be providing the committee with a report, or will you come back to us with the details of that?
No, I think it will be important for us as a committee to meet and look at also our program. I don't want a situation where you just say on this particular day and then you find that it is not possible, because Honorable Breitenbach has also raised the point about the many reports that you have to prepare. So it will be important that if you ask you to prepare a report, we know that we will consider it. So I think it will be important that we will have time as members of the portfolio committee and deliberate on the matter.
Thank you, Chair.
Thank you. Honorable Maseko Chele.
Yes, Chair. Thank you. I think you answered in a manner that also I needed to add, Chair, that I think this matter, Chair, for it to not to get the attention that it deserves, after we have, if we can get those documents, the very same report of Advocate Nzabeza, and these cases, the information that you just mentioned, Chair, if we get that information, we sit down. On my side, I was going to propose to the committee that why can't we, if possible, have a unit, Chair, within the ID, because now the matters are, there are a lot of them, and they might not, they do have a attention as we have been reported, but not to the satisfactory, Chair, a way that one would say indeed there is a progress the way we would want to see it. Chair. My proposal was going to say, if it's not too much, if we can get that unit, the unit that can deal with this issue in particular, Chair, give it a speed that it deserves, unless in fact maybe I'm asking too much. Chair, you'll indicate. Thank you.
Let's discuss it, members, as a committee outside of the NPA, and then we will communicate back to them what our decision would be. Because I'm generally looking at the program. It's quite packed, so there are many things to be considered. One of the issues is where the parties that we come from would allow a situation where early in the year we have a committee meeting. Those are some of the things that we need to consider. So I think let's have a discussion outside of the meeting. We can have our own meeting and discuss the matter.
Thank you, Chair.
Thank you very much. Thank you to the NPA. Thank you, Advocate Kok, and thank you, members. I think we finished before time, in fact, 2 minutes before the time that was proposed by Honorable Mkhwebane. Can we meet at 3?
Okay. Thank you.
Yes, Chair.
Thank you.
Thank you, Chair. Thank you for the opportunity.